We are live on YouTube and we are not recording yet.
Recording in progress.
Not yet, it isn't, lady. Okay, Thomas Malone on the record.
All right, are you Thomas Malone, Gary from the jail?
Yes, sir.
All right, Mr. Malone, you were indicted by the grand jury yesterday on charge of malicious assault on a peace officer, a first-degree felony. Failure to comply with the order of a second police officer, a third-degree felony. Count one alleges that on or about August the 11th of this year, the county caused or attempted to cause physical harm to Deputy Stephen Alexander by means of a deadly weapon to wet a courthouse floor, and he was a peace officer. Count two alleges that on or about the same day, the operator of a motor vehicle so willfully to elude the police officer after receiving physical awful signal to stop and causes substantial risk of physical harm to persons, serious physical harm to persons' property. Count one carries a sentence of between 3 and 11 years as minimum set by the judge, with up to an additional 50% possible, depending upon Department of Corrections. Now, count three carries a possible prison term between 9 and 36 months, and a fine of $10,000 and a suspension of 3 years to life. And count one carries a possible fine of $20,000. Now, you are entitled to have an attorney on this matter, and if you can't afford to hire one, won't be appointed. So you did fill out the paperwork for appointment of counsel. Well, you don't list an address. Where you put your address in the clause?
I just must miss that area.
You're homeless then?
42 South Street, my address.
What is it?
42 South Street.
418 South Street?
Okay. 42 South Street, Roseboro, Ohio.
4218?
4242.
4242. Okay, I'm sorry.
What town is that in?
That is Russell.
Okay.
Yes.
All right. And when's the last time you were employed?
I was working here.
Where were you working?
Worked at Ohio Valley Trust, Route 50.
Okay.
Worked there for about 2 months before I came up in here.
All right. Well, the court then will find that you're entitled to appointed counsel. I will appoint Attorney Dennis Kirk to represent you. And in the absence of counsel, entering a not guilty plea on your behalf. Set your bail review hearing for Friday, October 8th at 1 o'clock. First pre-trial in their case will be October 20 at 1 p.m. Final pre-trial will be November the 3rd, 1 p.m. All those hearings will be by Zoom. And the trial date will be set for November 15 at 8 a.m. Bond will be set in the amount of $20,000 plus your own promises, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony. And if convicted and sentenced on that regard in this case, you'll be under a pretrial supervision of the probation department at 117 East Main Street. We'll report to them immediately upon your release of make bond. Then report once a week for 4 weeks after that as they determine to go random drug testing that may order, provide phone number for home cell employer, recommended by probation to be evaluated for substance abuse and mental health issues and treatments indicated to enrollment and follow that during the pendency of this action. And you'll also be under house arrest if you make bond at your residence. You have to be at all times unless you're working, going to and from work, medical appointments, court proceedings, or appointments with a probation officer, attorney in this or any other case. They also attend any kind of schooling, job training, educational programming, etc., or church services other than that. You have to be at all times. If you don't comply, court can revoke your bond and have you held for further. We'll notify your attorney of the appointment. If you have any questions, Mr. Malone.
Yes, sir.
All right, thank you.
Thank you.
Barbara, the Carter case is going to be by Zoom.
Yeah,
Okay.
I have no hope it's not by Zoom.
Yeah,
I'm
we're
just
going
waiting on
that will be last, so.
Yeah, I'm just waiting
As
on
soon as we
it.
get done with the arrangements, we're gonna go to, this part. So we've got 3 more arrangements, so, if you wanna get on your phone,
I'm waiting on my client, that's all. The one that's coming in for in-person,
okay?
that's all.
Yeah, but I say we're gonna do the partner sentencing by Zoom,
Great.
so, as soon as I got 3 more cases in my 5 minutes, so. Maybe 10 minutes. All right, are you Ryan Henderson, appearing there from jail?
Yes, sir.
All right, this is case number 21 CR 169, State of Ohio versus Ryan Henderson. Henderson, you were indicted by the grand jury yesterday on aggravated trafficking of methamphetamine and aggravated possession of methamphetamine and a forfeiture. Now, the charge alleges in count 1 and on or about August 27, 2021, you knowingly prepared for shipment, shipped, transport, delivered, prepared for distribution, distributed methamphetamine and are not equal to exceeding 50 times involved, less than 100 times involved, knowing that you have reasonable cause to believe it was intended for sale or resale by you or another person. As a first degree felony, which carries a prison term which is mandatory between 3 and 11 years, is set by the judge with a maximum of up to additional 1/2 of that time, set by the judge to be ordered by the Department of Corrections. There's also a fine available of $20,000, I believe it's mandatory fine of $10,000, and a possible license suspension 6 months to 5 years. Now, 2 alleges you did the same thing, except you just, it's not alleged that it was for sale or resale. And it's the same offense, same penalty. And then count 3 seeks to forfeit a 2004 Jeep Liberty that was allegedly used in the instrumentality commission of facilitation of the offense. All right, Mr. Henderson, you're entitled to have an attorney in this matter, and if you cannot afford to hire one, the court will appoint one. And you have filled out the paperwork I see. Is everything on this correct?
Yes, sir.
When's the last time you were employed, Mr. Henderson?
A few months ago.
All right. Who was your attorney in the lower court for this?
Excuse me? Carol Davis.
All right.
She told me that she doesn't practice felonies in Highland County, but
Yeah, that is correct. Court appoints attorney William Armstrong to represent you. In the absence of counsel, the court enters a not guilty plea on his behalf. Court will set a bail review hearing for October the 8th at 1 o'clock by Zoom. First pre-trial will be October the 20th at 1 p.m. by Zoom. Pre-trial will be November the 3rd at 1 o'clock by Zoom. Trial by jury will be set for November (15) 8 a.m. set an amount of $10,000 plus your own recognizance. Your promise to appear. Fail to appear, you could be prosecuted for additional felony and sentenced for convicted. Sentenced in that regard, sentenced in this case, you'll also be required to pay a deposit of $171 for certain statutory required fees prior to your release. Make bond, you will be under the pretrial supervision of the probation department at 117 East Main Street. You're to report there immediately upon your release, and then once a week for 4 weeks, and after that, as they determine, the random drug test they may require. Provide phone numbers for home, cell, and employer, recommended by probation to evaluate substance use, mental health issues, and treatment syndicated to enroll in and follow after penalty this action. And you'll also be under house arrest for residents at 9470 Garner Lane, Main Bridge, which means you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings, in this or any other case. You can go to appointments with an attorney or probation officer, this or any other case, attend any kind of job training, educational programming, classes, etc. You may also attend church services, other than that, you have to be there all the time. If you fail to comply, then the court could revoke your bond and have you dealt with further court. You have any questions, Mr. Anderson?
That's right.
All right, we'll notify your attorney this morning.
Thank you.
Are you Jonathan Peterson appearing there from the jail?
Yes.
Okay, this is case number 21 CR 174. Dave Ohio versus Jonathan D. Peters, Douglas Peterson. Mr. Peterson, you were indicted by the grand jury yesterday on 2 counts of rape. The first count alleges that on or about June 1st of 2014 through August 1st of 2014, you engaged in sexual contact with a person identified as A.W. who was not your spouse. And that person was less than 13 years of age, being less than 10 years of age. That's a first-degree felony, which carries a maximum penalty of life without parole. And in count 2, alleges the same offense, the same time period. So both of those carry possible life sentences without parole. Also, designation of the Tier 3 sex offender. Now, you're entitled to have an attorney to represent you in this matter. If you cannot afford to hire an attorney, the court will appoint one for you. I see you have filled out the paperwork and a financial disclosure form. Is everything on this form correct? Everything on this form correct, Mr. Peterson?
Yes.
Right. When was the last time you were employed?
I think sometime last year.
Alright. Alright, the court will find that you are entitled to appoint counsel or appoint attorney Dennis Kirk to represent you and are not guilty plea on your behalf. Set your bond review hearing for Friday, October the 8th at 1 o'clock by Zoom. First pre-trial will be October the 20th at 1 p.m. That'll also be by Zoom. Your final pre-trial will be November the 3rd at 1 o'clock by Zoom. Trial date will be set for November the 15th at 8 a.m. That'll be in person. Bond will be set in the amount of $100,000. Unless your own recognizance, which is your promise to appear, if you fail to appear, you could be prosecuted for an additional felony and then convicted, sentenced on that no matter what happens in this case. You'll also be required to pay a deposit prior to release of $171 to secure payment of certain statutory required fees. Be required to report once a week for 4 weeks and thereafter as they determine undergo random drug testing they may order. Provide undergo random drug testing they may order. Provide current phone numbers from home self-employer. had no contact with the alleged victim, A.W. As recommended by probation, you'll be evaluated for substance abuse and mental health issues, and treatment indicated to enroll in and follow that during pendency of this action. You'll also be under house arrest should you make bail at your residence at 352 Johnson Street, Block 30. And means you have to be at all times, unless you're working, going to and from work, medical appointments, court proceedings, in this or any other case, appointments with an attorney or probation officer in this or any other case, and job training, education program, and any type for church services other than that, you have to be at all times. If you fail to comply, court should revoke your bond and have you dealt till further warning of court. We'll notify your attorney of this appointment and the hearing for Friday. Do you have any questions, Mr. Peterson?
No.
All right, thank you.
No.
All right, are you Carissa Purcell?
Yes, Your Honor.
All right, this is case number 21 CR 176, State of Ohio versus Carissa Purcell. She is appearing by video, by Zoom from the Justice Center. You were indicted by the grand jury yesterday, Ms. Purcell, and the style of the case is actually State of Ohio versus Carissa Frankie Dale Purcell. The charge alleges that on or about March 27, 2021, in this county, he did knowingly obtain, possess, or use methamphetamine. That's possession, aggravated possession of methamphetamine in fifth degree felony. There is a possible prison term of between 6 months and 12 months, and fine of $2,500. Possible license suspension 6 months to 5 years. Now you're entitled to have an attorney in this matter. Can't afford to hire one for an appointment for you. So you have filled out a financial disclosure form. Is everything on this correct?
Yes, Your Honor.
When's the last time you were employed, Ms. Purcell?
I was employed for a few days at Giovanni's in August, which I still have that job when I'm released in December for my misdemeanor time.
Okay. You've not been in court on this case before?
No, Your Honor.
Alright. Alright, the court will appoint attorney Danielle Witt of Hillsborough, Ohio, to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. My understanding, this is a summons only. You're being held in jail apparently on a misdemeanor charge, is that correct?
Yes, Your Honor.
Alright. Your bond is going to be an OR only, and that is your promise to appear, and if you fail to appear, then you could be prosecuted for an additional felony and a convicted sentence on that, regardless of what happens in this case. Now, you'll be required to pay a deposit within 30 days of your release for the $171 as for certain statutorily required fees. You'll also be under pretrial supervision when you are released, if you are before the case is completed. And if you are released, you report to the probation department immediately upon release. At 117 East Main Street, you know where that's located?
Yes, Your Honor.
Okay, you'll report there immediately after court. And then once a week or 4 weeks after that, as they determine under the random drug testing that they order, provide phone numbers for your home self-employer. Recommended by probation, you can evaluate for substance abuse and mental health issues, and the traits indicated to roll in and follow that for pendency of this action. You'll also be under house arrest at your residence at 101 Woodland Drive in Hillsborough. You have to be there at all times, unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You also attend any kind of educational training, job training, courses, classes, college, GED, etc. If you violate those terms, the court can revoke that and have you dealt with. Now, we'll set your first pre-trial for October the 20th at 2 p.m. by Zoom. final hearing, final pretrial will be, November 10th at 2 p.m. on Zoom. Trial date will be set for December 13th at 8 a.m. All right, we'll notify your attorney for appointment, and she will probably contact you if you're still in jail. If you get out of jail, contact her office and get her phone number there at the jail.
Okay.
You have any questions?
No, I'm on.
Thank you.
Thank you.
All right, we need Travis, Carter.
Okay,
Okay, this is case number 21 CR 77, State of Ohio versus Travis Carter. You know Travis Carter here in jail,
Yes, Your Honor.
all right? His attorney is Sarah Barber. She's appearing here in the conducted by Zoom. Also appearing on behalf of the state's prosecuting attorney Andy Collins, and represents the probation department also present for the hearing. This hearing is being conducted by Zoom due to COVID-19 issues, and Barber and you and your client both in agreement to conduct this hearing remotely by Zoom rather than in person in the courtroom.
Yes, Your Honor.
And you're okay with that, Mr. Carter?
Yes, Your Honor.
All right, now, Ms. Barber, my understanding you would like to have a couple minutes, we'll take a breakout session.
Yes, Your Honor.
All right. So what I'm going to do is create a breakout session there, Mr. Carter, and that would be you and Ms. Barber only. No one else will be able to see you or hear you. You may have to push a button there that puts you into this, and then when you're done, it'll say end the meeting or leave the breakout room, and you'll leave with that. All right.
We'll just okay. Once you're done, just.
Okay.
Okay. There we go. She went. There we go. Somehow I created two rooms.
two.
Recording in progress.
All right, the record reflect that Ms. Barker and Mr. Carter have returned from the breakout room. Mr. Carter, at any time, if you need to talk with Mr. Barker further, just tell me. We'll put you in another breakout session there since you're not present in the courtroom. If you do have any questions, just let me know. We'll be able to talk to them, okay?
All right, thank you.
All right, Mr. Carter has entered plea guilty to aggravated possession of methamphetamine, a fifth-degree felony. Court referred the matter for a pre-sentence investigation. I'm happy to do that. Did each of the attorneys have an opportunity to review the summary?
No.
Well, if you had the opportunity, did you do it?
No.
All right. Okay, Ms. Barker? Okay.
I wasn't aware it was done. I apologize, Your Honor.
Well, we can't have this, yeah, they're always done, and here a couple days beforehand, so, anyway, we'll go ahead and proceed. All right, Ms. Collins, anything you'd like to say regarding the sentencing?
Only what's contained within the plea agreement.
Ms. Barker?
Yes, Your
Just
Honor.
let's continue within the plea agreement, Your Honor.
Ms. Carter, anything you'd like to say?
No, Your Honor.
All right. My understanding that there's a holder on Mr. Carter for his Claremont County cases, but according to Ms. Sturgill, they're interested in him being admitted to drug court and not revoking him, getting him in residential treatment. Is that correct, Ms. Sturgill?
Yes, sir, and they have actually agreed to help us transport him next week if that's available on the 13th.
Okay. All right. Well, Mr. Carter, you applied for the drug court, and you have been screened by Mrs. Sturgill, and she did present a letter to the court Monday that indicated that you had indicated you wanted to participate. You did sign your acknowledgement of the program terms and conditions. And so you are aware, Mr. Carter, that if you want to go into the drug court office, that's something that you ask for. The court doesn't sentence people to go to drug court. It's a voluntary program. You've been in community control before. You've been in intervention lieu. That was unsuccessful. You spent time in prison. But you have had an ongoing drug problem for the last 5 years. It's pretty clear. And community control is what the court does to put persons under supervision with the hope that they can stay out of prison, not commit any further violations or offenses, and hopefully work on their issues. You know what that's like. Of course, you're in Claremont County. I can tell you Highland County's program, even regular probation, is more intense, but in any event, the drug court program is much more intense. Number one, if I put you in that, you're going to go to a residential treatment facility for probably 90 to 100 days. And then you'll be in a very intensive supervision program, which will require you to call in daily, decide whether to find out if you're going to be drug tested. Be drug tested probably at least 3 times a week for at least a couple of months, and then thereafter take them out. You'll be called in for drug testing periodically. Again, you have to call in every day, including weekends. You don't report for a test in the time you're allotted. It's a failed test and result in sanction. You'll also be in much more intensive treatment and have a more intense contact and more frequent contact with probation. There'll be a treatment team of the different people involved in your plan. So it's a much more intense program. Now, the difference between the two is this. The focus of the drug court docket is to help persons become and remain sober, whether it be controlled substances, alcohol, whatever. And then, because if you do remain sober, it's highly unlikely to commit another crime. But again, it's voluntary. So I do have your request for admission, and the recommendation from Ms. Sturgill is that you be admitted. Now, again, this is all contingent on Claremont County agreeing. I understand that they will, but something should happen. That's the judge. I don't know if the probation department is authorized to speak to the judge or not. But, generally, the judge will listen to that, at facilities, Claremont County, I see that's pretty frequent. So, you understand that you still have to deal with them, and then go with the treatment and be back here being drug court.
Yes, I do.
And, where is it you'll be living once you get out of, you are a resident of Highland County, right?
No, I'm a resident of Brown County, but
Brown County, okay, so
I
that's
don't
okay.
want to go, I don't want to go back home, because I feel if I keep doing the same old thing, I'm going to keep doing the same thing.
All right, well, they'll be working with you on that, but I just need to make sure, because being in Portland, you have to be a resident of either this county or adjoining county. So that's why I asked you. All right. So, anything else you'd like to say, Mr. Carter?
No, Your Honor.
All right. Well, the court then has reviewed the, present report, and, it's the decision of the court that you will be admitted into the drug court docket. And it's, the order of the court that you be put under community control under the supervision of the probation department for a period of 3 years, under the following conditions. First, would be required to comply with all of the conditions and requirements of the drug court program, description and attachments which you've been provided to you and which you have signed and acknowledged that you're aware of, filing this with the court. You'll also be required to obey all laws of all jurisdictions, conduct yourself in law abiding manner all the time. Must report when and as directed, be honest in all statements you make to the probation department, as well as any questions they ask you about your supervision. You must keep them informed of your residence and place of employment all the time. May not change either without prior permission in writing. May not leave the state of Ohio at any time without prior permission. For the change of address and employment is not required permission, but the legal state does. You have to have that passed with you all the time when you're out of state. You may not enter upon the grounds of any correctional facility once you're released from custody. Nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior permission in writing. You may not, and you're disqualified under federal and state law from your past record as well as this conviction from possessing, owning, purchasing, using, and having under your control any kind of firearm, ammunition, or dangerous ordnance. It's also a condition that you not have any of those while you're under control in this case, nor any other weapons of any kind. You're not permitted to purchase, possess, use, or have under your control any kind of controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of controlled substance, drug of abuse that has effects similar to controlled substances of drug of abuse, or any instrument, device, or thing that may be used to administer them and prepare them for administration, unless you have a lawful prescription for any of those items. And if you do, you must provide a copy of that within 24 hours of receipt to the probation department. You're not permitted to obtain a medical marijuana card while in the drug court docket. You must submit to drug testing when and as requested. You may not purchase, possess, use, or have under your control any kind of alcoholic beverage, nor may be present in places which sold, being consumed, even otherwise lawful. You're not permitted to associate with anyone who's a co-defendant in this case, or any other person that has criminal records, a member of the gang, another criminal group, or any other person that has in the past or could in the future, unless you commit criminal offense and violate these conditions, unless that's proved in writing by your supervising officer, and by any family members other than those you may have been living with immediately before the commission of these offenses, or this offense. After the date of this order, you may not marry or establish cohabitation in a common law marriage type relationship with another person without written permission. You must report any contact with law enforcement, any arrest, citation, conviction of the charge of violating the law, not later than the next business day after that occurred. If you're referred by the supervising officer or any other probation employee for evaluation or assessment for any other type of treatment, therapy, counseling, training, programming beyond that ordered by the court, you're submit to that. If there's any treatment recommended or counseling program recommended, you must enroll in and successfully complete that. You'll be required to apply for your treatment plan as recommended. It's not your decision whether to apply or not. If they say this is what we think you should do, what do you think? Your answer is yes, I'll do it. There's no options. Now, by being put under community control rather than being sentenced to prison, you're also deemed to consent to a search without a warrant of your person, your residence, vehicles owned by you, used by you, or any other property place where your family is under your control at any time, any officer of probation department. There'll be no fine, there'll be no license suspension in this case. You're order to pay the court costs and make payment arrangements to do that. And if you fail to pay the cost, then the court could order you a service and give you credit for each hour you work in an hourly rate set by for each hour work, reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, then you will be entitled to have a hearing. The probation department will have to notify you in writing of the allegations of violations. You'll be entitled to have an attorney at the hearing. If the outcome of the hearing is that you have failed to comply, then the court at that time can terminate you from the drug court docket and send you to prison for a period of 6 to 12 months and fine you $2,500. If that occurs on completion of the prison term that is imposed by the court, you will be subject to being under post-release control for a period of up to 2 years, because this is a 50-year felony under the supervision of the adult parole board. And they will impose the conditions, and you'll be supervised by a parole officer, and if they determine that you have failed to comply, they can return you to prison, they can serve an additional period beyond that ordered by the court of up to, in this case, 6 months for any one or more violations. However, if you commit a felony, then in addition to whatever sentence the judge, in this case you impose, that judge is also authorized to sentence you to an additional period, 1 year, whatever time left on that period of post-release control, whichever is greater. If that occurs, then that will be served consecutively with the sentence in the case. All right. Now, that completes the order of the court. Now, I'm releasing you to custody of Claremont County. Though you'll stay in our jail until they get you. And the event that they give you permission to go to, was it Massey House or no, counseling centers where you want this for?
Yes, sir, the counseling center.
All right. So you'll be going to counseling centers, bed available for you, I believe, next Thursday. Next Thursday. No, next Wednesday. May 13th. So hopefully they're going to have everything worked out for you to be able to go down there and take care of their charges either remotely or whatever. But if they decide to come pick you up and take you to Claremont County and then they release you, then you are to contact probation immediately and be available on the 13th to be conveyed. If you're still in custody down there and they agree to take you, that's wonderful too. They can take you. You are still here, they leave you up here, then, I guess probation worked out. All right, so anything further from council?
No, Your Honor.
All right, thank you. You have any questions, Mr. Carter?
No, I don't, thank you.
All right, thank you. All right, going to the Rackley, Lisa, going to be notified, and then we'll have Miss Hughes in person here. Miss Carter's already off, so she's on her way. Mr. King's here. All right, are you Andrew Rackley?
Yes, sir.
All right, this case number 20 CR 250, State of Ohio versus Andrew Rackley. Rackley was placed on community control for grand theft of a motor vehicle, a 4th-degree felony, on April 22nd of this year. There was a notification filed in court yesterday, Mr. Rackley. It alleges that you had failed to comply with those conditions, and alleges that you were found unconscious at Turtle Creek and administered Narcan. And after you were responsive, you tested positive for several illegal substances. Rule 18 alleges that you have failed to make any payments, $50 per month for restitution. And also says that you failed to comply with successful completion of your treatment, because after your overdose, Turtle Creek discharged you, feeling that you were not amenable to their program. All right. Now, entitled to have an attorney, Mr. Rackley. And, did you fill out a financial disclosure form there, Mr. Rackley?
Yes, Your Honor, I just faxed it up.
Oh, okay, all right, thank you. All right. All right, well, subject to the receipt of that report, the finance you are entitled to, appoint a counsel court will appoint attorney Catherine Hackner to represent you. Set a hearing on this map, or in this matter, for, next Thursday, that would be, October 14, 1 p.m. Will be held without law until that time. We'll notify your attorney of her appointment at the hearing. Mr. Rackley, you have any questions? All right, thank you. All right. Now, we want other hearings, are they in different districts, or just using one all the way?
I do not know. We have a 10:30 evidentiary on Halls.
All right, well, that completes the docket until 10:30. And that one is, that would be by Zoom. Mr. Collins, Jamie Collins.
Yes, we have Hughes right now for sentencing.
Yeah, I know, usually it'll be, and then, Hill. Harrison,
Those are in person, I believe.
okay, all right. So we'll end this session then, thank you. Halls is a separate invite today. All right.
Okay.
Is Ms. Hughes around?
I don't know, Ms. Berger was, she was picking up the PSI to review.
Tell Hank that sometimes no excuse is better than a poor excuse.
Yeah.
When I asked her if she read the available, she said she didn't know it was there. Well, that's a poor excuse. She should know it's there. It's always there. If it's not, I'll tell you. Yeah. My dad used to say, son, no excuse is better than a poor excuse. Teach that military. No excuse, sir.
Judge, do you have Hughes's file?
Pardon me?
Do you have Donna Hughes's file, or is it here?
Thanks, right there.
Okay, PSI's in it.
When's our next case of the day? I'll have a meeting. Okay.
Yes, sir.
Case number 21, CRC, State of Ohio versus Donald B. Hughes, State Assistant Prosecuting Attorney Matt King, first on behalf of Defense Attorney Sarah Barter. Donald B. Hughes.
Yes, sir.
Ms. Hughes is entered a plea of guilty to grant theft of a motor vehicle by deception for a felony. Matters referred to the probation department for a pre-sentence report. Have received that. Have each of the attorneys received a summary.
State of the order.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
And what's contained in the plea agreement regarding restitution in this case is $2,965 less
Thank you. Ms. Barber?
Your Honor, my client has asked me to address a couple things that were listed in her pre-sentence investigation report. There was a mention that she has not been appearing consistently for her appointments at Brightview for treatment. She had an issue with transportation getting to group. That's been fixed. She can now appear by Zoom if she can't get there. She is willing to go today and make a payment on restitution. She's aware of the amount, and she does want to make Westview Motors whole.
All right. So, use anything you want to say?
Yes, ma'am. I'm sorry. I like to tell the court I'm sorry. I made a mistake. I'd like to get a restitution paid. And remember. But I'm very sorry that I made a mistake.
All right. Anything else?
We run.
So you are currently attending your session at Brightview?
Yes. Yes.
All right. This is the defendant's first felony conviction. Percent report. Previous criminal offenses, most of those are traffic related. There's a passing a bad check card. Previous theft of use. It's your report that you be placed under control for a period of 3 years under the supervision of the probation department of County. You'll be required to comply with these conditions. First, you're to obey all laws and all jurisdictions, conduct yourself in all fine manner at all time. So your report when and as directed. Will be required to be truthful in all statements you make to the probation department, as well as any answers you give to them regarding questions that they may ask you. Regarding your supervision, you'll be required to keep them informed of your place of employment at all times, as well as your residence, not to change either without prior permission. May not leave the state at any time without prior written permission. You must have a copy of that pass with you when you go out of state. You may not enter upon the grounds of any correctional facility. You won't be communicating with anyone who's an inmate or you communicate with anyone who's an inmate in his facility without prior written permission. You're not a person that's used to have under control any kind of firearm, ammunition, dangerous orders, weapon of any other type. You may not purchase, possess, use, have under control any kind of controlled substance, drug abuse, CBD, oil, crack, or any other variant analog of any controlled substance, drug abuse that has effect similar to those. Nor are you permitted to have any instrument, device, or thing may be used to administer drugs or prepare them for use or administration unless you have a lawful prescription for any of those items, and if you do, you have to provide a copy of that from your probation department and Flint Rockers. See, you must submit to drug testing when and as requested. You're not to purchase, possess, use, or have under control any alcoholic beverage, nor will be present in places where the sold being consumed, even if otherwise lawful. You're not to associate with anyone who is a co-defendant in this case, or any other person who has in the past or in the future influence you to commit a criminal offense to violate these conditions. unless approved in writing by your supervising officer that applies to any family members that may fall within that definition, unless you're limited to that immediately before this offense was committed. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another person without written permission. Unless report any contact with law enforcement or any arrest, citation, conviction, or other charge violating the law, not later than the next business day after that occurs. Must provide your supervising officer with financial information records such as your ability to pay restitution, fees, and costs to be reviewed. You're referred by the probation department or any other evaluation assessment for any treatment beyond that ordered by the court. We submit to that and then a recommendation for any treatment, therapy, counseling, or other programming or enrollment assessment with that. You're required to pay the court costs of this action and make payment arrangements to do that. Now, are you working
That's that Edgewood Hotel.
where?
Edgewood Hotel.
Okay.
Your Honor, she has expressed that she's currently a volunteer at Edgewood. When they have an opening for an aide, she would be part-time.
All right, we pay the court costs of this action, make payment arrangements to do that. We also pay restitution. And I've got it set at $100 a month beginning November 1st for the payment plan. Because you're, three years is 36 months. And you have $2,951 in order to pay to Westview, $2,965 to Westview Motors. And you'll have to pay those through the probation or witness escrow account. And there's a fee that you have to pay for each payment. The reason I'm doing that is because if you get behind schedule, you're not going to get off of paper for a year. And they will file a notice that you have failed to comply with that condition. And most likely work will extend it. I can't put you in 5 years of legal control. I'd rather not do that because my policy is I don't let anyone off any earlier than 1/2 of the time. Assuming they're fully compliant and paid all their fees. And if I make it 5 years, that means you're going to have to wait 2.5. This way, if you get a tax refund or something, some other way to pay that off ahead of time, then that will allow you to get off in 18 months, assuming you're fully compliant and finish your treatment and so forth. But it's not a promise, that's just my policy. So right now, I'll just leave it at 3 years, but just know this, that if you don't get paid, you need my schedule, the probation department comes in, you're probably going to have your time extended. Now, by being placed on community control rather than being sentenced to prison, only back that period where you successfully complete right view, substance use disorder program, and any aftercare they recommend. By being placed on community control sanctions rather than being sentenced to prison, you're deemed consented to serve without a warrant for person, residence, vehicles, owned by you, or used by you, or any other property placed and under control or ordered down at any time, any officer of the probation department. Be no fine imposed. Restitution is ordered in the amount of $2,965 for Western Motor paid for the witness escrow account. We also pay the court costs, and if you don't make payments on the court costs, the court clerk will collect that through various forms of means, including letting on bank accounts, wages, or other assets you may have. That doesn't collect it, then the court will give you community service in this county and give you credit for each hour you work, and hour they sent to the court. Each hour you work, you reduce your judgment by that amount, you'll pay the full. Now, in the event that it's alleged that you have failed to comply with these conditions, then the court can revoke the community control. If that occurs, then you will be sentenced to a term of imprisonment between 6 and 18 months, and fined up to $5,000. If that happens, upon completion of the prison term imposed by the court, you could be placed under post-release control supervision by the parole authority at their option for a period of up to 2 years, which means you can be supervised on the conditions they set. And if they determine that you fail to comply, they could return to prison and they can serve an additional period of up to 9 months for any one violation. But there is a cap of half, whatever the prison term was, for all violations. But if you committed a felony, then in addition to a sense of judgment, The new case proposed finding that judge could also sentence you in this case for committing that new offense under post-release control, in this case, to additional period of 1 year, or whatever time's left on that 3 years of post-release control, whichever is greater. That occurred, then be served consecutively sentenced in the case. And no longer under pretrial supervision, which are report probation department immediately after this hearing, to let them know you were sentenced, and you'll be transferred to a different officer under the new program. All right, does that include counsel? All right, report probation, thank you.
Please rise. Thank you.
Are you, Jamie Hall's attorney from the jail?
Is looking for like a camera that we can be able to put somewhere, like for instance, like put it up at North End Mini Mart,
I'll get some extraneous video or audio from somewhere.
the computer where, you know, we got somebody at the office. Yeah.
That sounds like Randy Sanders.
I think that's, from your office, Ms. Collins.
And boys,
Sound like Mr. Sanders.
they're leaving.
Okay, all right. Okay, now, this hearing is being conducted by Zoom because of COVID. And this, with, his attorney is appearing by video, or by Zoom from her office, Ms. Collins on behalf of the state from her office. Ms. Which you and Klein are both consenting to this matter being heard remotely rather than in person.
I would talk to her first.
Yeah, I'm gonna let you do that, but I just wanna get on record, it's all right, you can do it this way.
Oh, yeah.
All right, okay. All right, so we're gonna put you in the breakout room so that you and she can speak for a minute. When I do, there should be something on the screen that says join breakout room, and I'm going to do that now. When it's done, then you need to push a button that says leave the room.
Thank you.
Basically, protocol responsible to sit down there.
Yeah.
Yeah.
Program, responsible.
Yeah. That's the,
Okay, you should be going there shortly there, Mr. Laws.
Might be 24
Yeah. You should click on that, if it says join room one. Shows that she's in there, I know she's in there. There we go. What's going on this time this morning? This is weird.
Okay, pause and silence YouTube. Go back on Zoom and resume.
Recording in progress.
Okay.
All right, correct, reflect that, Lieutenant Council have returned, from the breakout session. All right, this is a hearing on a, allegation of a violation of the term of community control. Mr. Paws was convicted in case number 17 CR 162 of possession of heroin, a fifth degree felony, and 19 CR 80 failure to appear, a fourth degree felony. He was placed on community control in both cases on July 13th of 2019, and the notification of alleged violations was filed on September 24th. The court appointed Mrs. to represent the defendant and then set the matter for evidentiary hearings today. All right, Ms. Witt, you consulted with your client. Do you wish to have a hearing on his allegations?
No, Your Honor, he will be admitting to the violations.
All right. Mr. Hawes, the allegations are that you have violated Rule 2 in that you failed to report to the probation department since May 13, 2021. Rule 15, that you still owe $974.50 to the clerk of court for court costs. And in Rule 20A, that according to the records of the probation department, you have not enrolled in any aftercare as you were directed to do after you completed Massey House residential treatment. Those are the allegations that were filed on the 24th of September, which I notified you of. And in the event that you are found to have violated these conditions, if you admit to it or if there's a hearing, one of three things can happen. Continue community control under the same conditions, and continue it under additional conditions that they are appropriate. Or the third, the most serious item, revoke community control and send you to prison in each case. In the 17 CR 162, that could be between 6 and 12 months. And 19 CR 80 could be between 6 and 18 months. Those could be served consecutively. So you could be sentenced to anywhere from 6 months to 30 months, as well as fined $7,500. Now you are entitled to have a hearing on these allegations, which is what we're here for. And in that hearing, the prosecutor would have to present evidence to prove to the court's satisfaction that you committed these violations. You can have your attorney cross-examine the witnesses the state presents and try to bring out evidence to help your side of the case. You can testify on your own behalf, although you're not required to do so. You can also present other evidence or other witnesses if you have any. Now, do you understand all those things, Mr. Hawes?
Yes, sir. Yes, Your Honor.
Has anyone threatened you with anything to get you to admit to these violations here this morning?
No, Your Honor.
Has anyone promised you anything if you admit to these violations?
No, Your Honor.
All right. Do you have any questions about your rights or the allegations?
Yes.
Do you understand them?
Yes, sir.
Do you understand the consequences, potential consequences if you admit to these violations here this morning?
Yes, Your Honor.
Okay. Then do you admit to the allegations that were filed at the notification on September 24, 2021 that I just went over with?
Yes, Your Honor.
All right. All right. Anything from the state or probation department regarding this position?
I'm actually not sure what the probation department's position is on sentencing. The state would ask the court to revoke the defendant's community control. I'm not sure if he is currently in the drug court program or not.
No, he's not.
Your entry from the last probation violation indicated that he would be assessed, but that's the last thing I have.
Right.
He failed to appear while this case was pending, while his original case was pending. This, as far as I can tell, is at least his second probation violation. He has a history of not reporting and not participating in drug treatment. He's been given multiple opportunities to benefit from the various programs that probation offers. He's clearly not interested in that. So based on all of that, the state would request the defendant's probation be revoked and he be sentenced to a term of incarceration.
Ms. Witt, anything you'd like to say?
Yes, Your Honor. While it's clear that Jamie has not, coincided well with probation. He has not, from what he's told me, veered too far off course. He has stayed clean in this time period and, expressed to me that he hasn't used heroin, since this charge and those facts of that case. Drug court, I think, would be a good opportunity for him to be held to that accountability. And speaking with him, it sounds like he has a plan of action and knows what he needs to do. He resides closer to his treatment facility now, and he is working, he's been clean, he's a stable income. So just ask the court to consider him for drug court and be assessed so that he can have that level of accountability and keep on the path that he didn't veer too far from while he didn't follow all of the rules he was supposed to do. I think that he can still come back from this and head in that direction.
Paul, anything you'd like to say?
Yeah, I understand that I'm responsible for everything that I cause myself, but I've stayed focused on my sobriety and everything. I got a family that's counting on me and everything. I will start paying on my fines and everything. I just got a job working at a horse farm, and I moved way closer to where I'm within walking distance. I'm going to my aftercare and everything, to where I don't have no excuse or anything for not following up with the dog. And I just want the opportunity to show you that I will not fail at this. And drug court, I would love to have the accountability, and I know that I have to stay focused on my sobriety, on myself, and my family. I don't want to go to prison, plain and simple. I've never been, and I will not fail if you give me one last opportunity to show you that I can do this.
Well, where were you living?
I was living in Hartsville, where it was hard for me to get around because I don't have a driver's license. But the woman I'm with now, she told me she would take me to everything I need to do, take me to my probation and all that, and then my aftercare and all that. I literally just got it all set up right before I got arrested. And I don't really have an excuse because it's hard for me to get around where I was at in Hartsville. But I got it a lot easier now and everything, and I'm staying focused on what's.
Where's the place you work? You have a job.
It's called Red Gate Farm. They train racehorses.
Where is it?
It's in Rochester.
In Lancaster?
Morrow.
Oh, in Morrow.
Yeah.
Right. And how long have you lived with this woman you talked about?
I literally just moved in like 3 days.
What's her name?
Brianna Wilson.
And does she have a job?
No, she's disabled.
She's disabled.
Yeah,
Okay.
She has.
So why did you quit communicating with the probation department?
My phone got broken and everything, and.
What did?
What
broke?
My phone.
Okay. And where were you living when you quit reporting?
I went back to Clarksville. Clarksville's been a nightmare.
Well, did the probation department know that?
Yeah, I told them where I was living at and everything, but it's been a nightmare living there, and I'm not going back there because all it's done is caused me more problems than what's living out in my hometown, and I don't want to go back there again. And I will stay away from there, stay focused on my sobriety and getting my fines paid off, everything, and my family.
So when's the last time you used?
It's been a while.
You know, most people that are sober have the exact date. They can tell me. 47
Your Honor,
years.
the state would like to be heard again.
Okay, go ahead.
He admitted to probation that he used on September the 24th of 2021. He also reported in May, and when he was assessed for drug court, and he refused to be admitted. That's why he's not in drug court. His choice.
Right.
But he admitted to Sandy Kelly that he used on September the 24th of 2021 methamphetamine. So his statement to the court just now is inaccurate.
Maybe he doesn't know what a wild means, so.
Perhaps.
All right, anything else you want to say, Mr. Hollins?
I don't know, excuse, I did it because I was working and everything, and I'm done with it. I don't want, I just got my family and everything, I don't want to lose it all, because, my ignorance. I ain't gonna put it off on anyone or anything else, and I will stay focused on what is important. I like drug court, I didn't refuse it, I had the option of it. And it was transportation problems is why I didn't take it when I first got out. But I have the transportation needs and everything now to do all this. That's why I didn't do it before.
Ms. Kelly, were you aware where he was living when he quit reporting?
Your Honor, he reported to me when he was released from Massey on May the 6th. He had called me on May the 5th, stated that he had a job interview and he couldn't report any sooner. When he reported to me on May the 6th, he stated that he had no interest in drug court. He was supposed to report again, he failed to report. I tried to contact him by his phone, it was disconnected. I tried to make contact with his home, but there was no success. I also sent a letter to the Clarksburg address with no success. I tried to talk to his elderly mother, who stated she would try to get a message to him. When I served his violations on September 24th at Highland Justice Center, he admitted to using ice to me that he was failing right straight.
All right. Anything else from the state?
No, Your Honor.
Anything else, Ms. Whitten?
No, Your Honor.
Anything else you'd like to say, Mr. Hollins?
I just would like one opportunity in drug court is all. I will do everything that's necessary, and I will stay focused and stay away from drugs. Because my little girl, well, she ain't mine, she's my girlfriend's little girl, but she counsels me now, and that was much more important to me than using drugs.
All right. Well, Mr. Hawes, you're an example of somebody who probably should have quit talking a long time ago. And it's apparent to me that you're not being honest with a lot of people, including yourself. I mean, apparently, if you told your attorney hadn't been using it, you've been clean, and that's not the case. And you said you don't want to go to prison and you want to go to drug court. Well, that's the wrong reason to go to drug court. Because that's not a perfect drug court, it's to get you clean. And you were offered that opportunity, and you said, no, I didn't want it. It wasn't optional, it wasn't mandatory. I don't order people in the drug court. But if you were serious about your sobriety, when Ms. Kelly talked to you about it, back at the time you got done with your treatment, you should have done it. And you didn't. And it's pretty clear to me that what you want to do is stay out of prison. That's what you said. And you want a chance. And, I've already given you a chance. They gave you, the first time you were indicted, and looked back in 2017, and you didn't show up for a hearing. And so then you got indicted again. And it was like, 2 years. You were indicted in May of 2019 for failure to appear. Well, that was in April of 2019. But you had been indicted in that case in September of 17. And they weren't able to find you, summons, so there was a warrant issued for you. And on October 6th of 2017, and that wasn't returned until March 15th of 2019. And then after you were brought in, then you failed to appear, you were indicted back, and you parole. You were assessed for intervention of conviction, because you've been medically released from the Justice Center, and you did report probation for that, so that was a failure to appear. You had numerous chances, and you completed FRS, Massey House, I believe, completed STAR, but you just haven't followed through with anything, and you're basically lying to it. So, it's the judgment of the court that you have failed to respond favorably to control. So, the court votes your community control, and then 17 CR 162, it's ordered that you be sentenced to a term of 8 months in the Correctional Reception Center in Ohio. In 19 CR 80, you're sentenced to 10 months. Those are to be served consecutively for a total of 18 months. And the court finds that those are appropriate because you committed the second offense on control first. There are several courses of conduct. Your behavior demonstrates that it is necessary to protect public from future crime, and also one single sentence of non-accurate medical services. According to the sheriff, you're entitled to 53 days of jail time credit. Some of the time you spent in jail on 17 CR 162 was spent on pedestrian court cases, as well as in 2020. How many days were you to start?
147.
How many?
147.
Okay, well, that speaks a lot, because that's really long, most of them about 90 to 100. So that means that you didn't do very well. You got through, but you didn't do very well. So the court will give you, that means you get a total of 200 days to give credit. Now, upon completion of this sentence, the Adult Parole Authority may, at their option, choose to put you on post-release control supervision for a period of up to 2 years. If they do, you'll be supervised in the terms they set, and during that period of time you fail to comply, they can return you to prison, make you serve an additional period of up to 9 months for one violation up to a maximum of half your prison term, which in this case is the same, 9 months for all violations. But if you committed a felony, then in addition to whatever sentence the judge in the new case imposed on you, the judge can also sentence you in this case to an additional term of 1 year, whatever time left on the period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence. In the new case, you're also paying court costs. If you don't do that, court conduct active various means to be levied on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon your release from prison, then you may do community service in this county. You get credit for each hour you work, and then however they set by the court. And each hour you work will reduce your judgment by that time. All right. Is there anything further, counsel?
No, Your Honor.
No, Your Honor.
All right. You remain in custody. All right. All right. Mayor Hill. All right, case number 21 CR 85, State of Ohio versus Jared R. Hill. Present for the state is the assistant prosecuting attorney Adam King. Present for the defendant, attorney Sarah Barker. And are you, Jared R. Hill?
Yes, sir.
Mr. Hill entered a plea of guilty to aggravated trafficking, theft, violation 2925.0381, A43 felony. The court received a pre-sentence report at this order, and I have reviewed that, and each of the attorneys received a summary.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor. There is a restitution in this case of $60 to the Highland County Task Force.
50 or 60?
60.
Okay, that's what I thought.
Your Honor, the only thing that I would say is that my client has reported to me this morning that he is working, he's working when he can. He was recently went through an illness, and he's just now recovered, so he has started working again.
Bill, anything you'd like to say? You have nothing to say? All right. Well, according to the report, Mr. Hill is not reported to the probation department since I think, let's see. And I don't believe he reported for a pre-sentence interview as well.
Your Honor.
Yes.
My client was, he did do his pre-sentence report, however it was while he was in jail.
I was in the Highland County Justice Center until 12.
All right. But you did not report after your release from jail.
I was released due to COVID symptoms. The hospital should be faxing the paperwork.
Do you have proof you had COVID?
The hospital's faxing the paperwork over here.
Oh, just right now?
I
see. When was that?
I got out at 12, and that's the reason I was released was due to COVID.
Right.
And then I've been on quarantine since.
Been what?
I've been on quarantine since I came. I had.
Well, you're only on quarantine for 10 days after sentence. I had it. I got the letter. I know.
I understand that, sir.
Yeah, so that would have been 22nd September.
Right.
You've not been in contact with the patient since then.
I came to court. He told me to come back in 10 days. That's why my schedule. So I had them fax the paperwork today.
And you've not been to, you've
I've
not been to FRS either, I don't believe.
I went and got the assessment.
When was that?
That was a few days before I went to jail, but I'll have to be reassessed since I didn't get back to classes.
Mr. Archibald, did you get anything from that?
No, Your Honor.
All right. Did you was in contact with you after you got out of jail?
No, Your Honor. We were all the things people out of time.
And you have nothing from FRS that indicates he's been there for assessment?
That's correct.
I mean, a lot of what I'm looking at here from FRS was on August 20th. Shows the last time that he was there was in February 18th. Is that the only information you have in that?
Yes, Your Honor.
All right. You said you were working?
Sir,
How did you work during quarantine?
I wasn't. I just started work this week on Monday.
Where were you working?
Footer Express for Nathan Ryan.
So have you been been assessed by the by FRS for substance abuse?
I went to get my assessment, but I had misdemeanor court and I got put in jail on the 24th.
So you haven't. Okay.
I have to go get reassessed, sir.
All right. All right. Let's see. There was a court that you are going to be put on community control for 33 years. This is your first offense, felony. And basically it's mandated. have serious doubts that you'll be successful because, you, number one, you are failing the attitude test terribly. And number two, I think that the team is aligned forward. But nonetheless, it's important to be put under control for a period of time. Supervision probation department under these conditions. You're to obey all laws, all jurisdictions, conduct yourself in a law-abiding manner on time, report when and as directed. Be truthful on statements you make to the probation department regarding your control. You must keep informed of residence, place, and employment all time, and entertain guidance without prior permission. You may not leave the state of Ohio without prior permission. You may not enter upon the grounds of any correctional facility or communicate with anyone who's an inmate or attempt to communicate with anyone who's an inmate in the facility without prior written permission. Because of this conviction, you're not permitted to purchase, possess, own, use, or have under your control any firearm, ammunition, or dangerous ordnance. To do so would be a violation of both federal and state law, subjecting you to prosecution for felony in either or both of those jurisdictions. It's also a condition that you not have under your control, nor any other weapons of any other type. You're not permitted to purchase, possess, use, have under your control any controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any of those that may have effects similar to those, or any other instrument, device, or thing that may be used to administer them, prepare them for administration, except those which have lawful prescription, and must provide a compact and wrong. You submit to drug testing when and as directed. You may not purchase, possess, use, have under your control any alcoholic beverage, nor may you possess in place of the soul being consumed himself by lawful. Not to associate with anyone as a co-defendant in this case, or any other person in the criminal record, member gang, or any other criminal group, or any person who has in the past, or could in the future influence you to violate these conditions, or commit a criminal offense unless you have approval writing, or supervised officer that apply to any family members of those residing at the means of prior commission of the offense. After the date of this order, you may not marry or establish cohabitation or common law marriage type relationship with another without their permission. Must report any contact with law enforcement, or arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. Provide your supervising officer financial information records so your building paying fee cost will be reviewed. If probation refers you for any treatment or evaluation or any kind of programming, then you will submit to that. If there's any recommendation programming, you will complete that. Pay the court costs of this action, make payment rate for reports. If we require to do 4 hours a week service, 20 hours a week, 20 consecutive weeks, unless you're employed these 20 hours a week, you have documentation, position, or current disability, body, and physically unable to do that. Your order to be held in the custody of the sheriff and jail today until you can be assessed by the probation department and FRS for substance use disorder treatment and aftercare. If they recommend residential treatment, then you'll remain in jail until that's available. If not, you'll be released. And conditions of supervision will start at that time. Now, by being placed under community control rather than being sentenced to jail, you're deemed to consent to a search without a warrant of your person, residence, vehicles owned by you, used by you, or any property places under your control where you're found at any time, any officer of the probation department. Will not be assessed a fine. There will be no suspension of driving privileges. It's ordered that you pay $60 restitution to Miami County Drug Task Force through the victim escrow account. You're to make those payments as a condition of control as well. You're also to make arrangements to pay the court costs to the clerk reports, and if you fail to do so, that's a violation of control. If you fail to make payments, then the court clerk can collect that through various means, including letters on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then you can be ordered to be serviced above that already ordered. And if you give credit, if you got work not only set by the court, you try to work, reduce your credit by that amount until they full. Now, in the event that it's alleged that you failed to comply with these conditions, then the probation department will file a written notice of that with the court. You'll be entitled to have a hearing, and if the outcome of that hearing is failed to comply, then the court can revoke community control at that time, sentence you to a term of between 6 and 18 months in prison, fine you $5,000. If that happens, once you complete the prison term set by the court, it's optional whether you be placed on post-release control by the adult role. That means you'll be supervised on the conditions they set, and in the event that they determine that you are not in compliance with those conditions, they can return you to prison, make you serve an additional period of up to 9 months for one violation of half of prison term for all violations, but committed a felony, then an additional order sentence the judge in due case imposed upon you. That judge is also authorized to sentence you in this case for an additional 31-year order of conduct on entry as opposed to control check greater. If that occurs, that must be served consecutively to sentence in the case. All right, you'll be taken into custody and evaluated. As far as you let us say the evaluation immediately, and as I said, if they recommend residential treatment, then you're going to remain in jail till you go to bed. If they recommend outpatient, then you'll be released for probation immediately. Yeah. Do you have any questions, Mr. Hill?
How long will I be in jail, sir?
I don't know, but depends on how long it will take them to get the assessment done. So, and then you're going to get the recommendation for treatment. You're going to have to apply that. That may be residential treatment. So they go, but you're going to be in jail until that question is determined. Like I said, residential recommended, and that's where you're going. And if they don't recommend it, they recommend outpatient, then you'll be released and you report probation and start your treatment that way. Anything further, counsel?
No, Your Honor.
There you go.
All right, remain in custody. All right, Michael Harrison.
All right, Your Honor.
Okay. Case number 21, CR 116, State of Ohio versus Michael C. Harrison, President for the state, Assistant Prosecutor Adam King, President of the defendant is Attorney Sarah Carter. Are you Michael C. Harrison?
Yes, sir.
All right, Mr. Harrison is charged with aggravated possession of methamphetamine and fifth-degree felony. Defendant filed a motion for consideration for intervention with conviction, and stipulated questions were also filed with the court. The court has received a report from the probation department, and I have actually a really thick packet of paper from another chance. In Greenville, Ohio office indicating that Mr. Harrison has been in IOP and has attended 11 verbs. He missed 2 months in jail. Says he's doing well. One second, about 12 months and he go to AOP. So he is in a certified treatment program. I reviewed the report from the probation department, and he does appear to meet the criteria. Now, I then presented them Mr. Harrison with a plea of guilty form along with an entry that would put you into what's called the intervention program. Now, generally under Ohio law, a person pleads guilty, they're found guilty, and then there's a sentence imposed. That sentence can be a prison term, it can be a fine. In cases like this, it could be a suspension of driving privileges for 26 months and 5 years. Or it could be a prison term, or it could be a combination, community control, which is probation. It could be a combination of those. Now, there is a program that you qualify for that is a client that provides that if a person pleads guilty to a charge in which it's indicated that their history of substance abuse or alcoholism or mental health was a significant factor in committing the offense, and if they're in a certified treatment program, which you are, then they qualify for this whole intervention to a conviction. What that means is that although you plead guilty to the charge here this morning, I don't find you guilty. Instead, I stay. Stay is a legal term that means stop or freeze. So in other words, it's inactive, and nothing happens until I get a report back from the probation department as to your progress in the program. Now, in addition, and what that means is you will have to be in compliance with your treatment program. One of the conditions of which is that you must not use alcohol or drugs for a period of at least 1 year. And you have to comply with certain conditions of supervision and probation department, which are not as strict as many as an employed person who is actually there. Now, that program requires, like you said, that you be alcohol and drug for a period of 1 year. Now, the advantage to you is this: if you complete the program successfully, once I'm notified of that, the charge is dismissed, even though you pled guilty. Because even though there's a guilty plea in the file, until I put on an entry in that file that says you're guilty and impose the sentence, you're not guilty, you don't have a felony conviction. And if you do all the things you're required to do, pay your court costs and stay clean, then the case will be dismissed, and I will set the matter for a hearing to seal the record in most cases. Actually, I think every case, I'm sealed the record. In cases where we've had people do this successfully. And if that happens, that means you've never been convicted, even though you pled guilty, and you're never considered a felon because of this case. Now, the disadvantage to you is that this is your last chance to stand up and prove not guilty. And so, what that means is that you don't get to go into the program trial and it doesn't work, come back and say, okay, let's have a trial. Because you're going to be guilty. So, understand that?
Yes.
Okay. Now, the agreement that I have here is 4 pages long, including the entry. On page 3, there are signature lines. Up at the top of the page are the sentence that says, enter this plea voluntarily. Then I see a signature with a date of 9/1/21. And you recall signing this agreement about a little over a month ago.
Yes.
And you signed it at this, Ms. Barker was present.
Yes.
Did she explain everything to you so that you understood it?
Yes, sir.
And you understand that by signing this, you're agreeing to plead guilty and it won't be a trial, move to the next step.
Yes.
And are you entering in this agreement to plead guilty voluntarily?
Excuse me?
Are you pleading guilty voluntarily?
Yes.
No one's threatened you in any way to make that. All right. Now, the agreement says you're going to plead guilty to the charge, which is aggravated possession of methamphetamine under 2925.11 advice code 53 felony. Further states you understand the maximum penalty for that could be 12 months, the minimum would be 6 if there was a prison term imposed. There could be a fine of up to $2,500, could be a license suspension 6 months to 5 years. You understand all that? And you're not facing any felony charges anywhere else. And you're not on probation or community control, parole, or post-release control for a felony in any jurisdiction. Right? Now, in the event that I grant your request, which I intend to do, legally, you will be under supervision for a period of 2 years. All sessions go up to 5. I generally set it 2 because 2 is you, and it has to be at least 1 because the requirements to be drug and alcohol for a year. And so I feel that 2 years is usually an adequate period of time to determine if the person is going to be successful in the program or not. And so that's what I will plan on doing. Now, in the event that it's alleged that you have failed to comply with those conditions, probation will have to have a hearing, or you file a notice of the allegation, and then there will be a hearing. You can have an attorney at that hearing, and then if the outcome of the hearing wasn't you failed to comply, then at that time you would be found guilty of the charge, and then you would be sentenced. If that happens, then the court at that time could sentence you to prison for 6 to 12 months, fine you $2,500, suspend your license for 6 months to 5 years. Or I could put you on community control, because that's probation for someone who's been convicted. That can also be for up to 5 years. Those conditions would be more numerous and stricter than the ones that you'd be under in this program. And like this program, in the event that during that period of time you were being supervised, probation felt that you were not in compliance, you would again have to file a written notice out to the court, be a hearing, you'd be entitled to have an attorney at the hearing. And if the outcome of the hearing was that you failed to comply, apply, then at that time, the court could terminate the control, then send you to a prison term between 6 to 12 months, and fine you $2,500. You understand that? Now, if that should occur, once you complete the prison term that was imposed by the court, the rule authority has the option to put you under post-release control supervision for a period of up to 2 years. And if during that period of time they determine that you have failed to comply, then at that time they can revoke your name, or they could return you to prison. Make you serve an additional period of up to, in this case, half of whatever prison term is imposed for one or more violations. But if you committed a felony, and in addition, whatever sentence a judge in that new case could impose upon you, that judge could also sentence you in this case for committing that violation during the post-release control in this case. For an additional period of 1 year, or whatever time's left upon the 3 years of post-release control, whichever is greater. If that occurred, then that was served consecutively to the sentence in the new case. You understand that?
Yes.
Now, do you hold any license or certification from any state, board, or agency for any kind of job or occupation or profession? Do you have certain constitutional rights I mentioned, which you must understand before acceptability? Because again, this is your last chance to stand on a guilty plea and then have a trial. That's what you want. So, first of all, you have a right to have counsel. Ms. Barker is appointed to represent you, not simply to work the case out, but to provide any defense to you that could be available to you under the law that you wish her to provide. Now, if you didn't, if you decide you don't want to do this, you will still be represented by an attorney with Ms. Barker, and she would manage you with you in trial if that's what you want. You understand that?
Yes.
Under the Constitution, you have a right to a jury trial in this matter. There's 12 people to be selected from a group of citizens and summons for jury duty that reside in this county on your trial day. After they were selected, the evidence would be presented, and then the judge would instruct them on the law. And then that jury would have to decide unanimously, meaning all 12 would have to agree on whether the state proves your guilt on the charge. If you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive the right, which means to give up, right to have a jury trial, and then in that case you have to hold it for a bench trial, meaning the judge would be the one to hear the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt and prove the arguments were done. You understand that?
Yes.
Now, under the Constitution, you have a right to have the witnesses, to confront the witnesses against you and cross-examine them in open court for your term. So what that means is witnesses against you have to come into court, testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions, that's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
We're not picking him up, Your Honor.
Pardon me?
We're not picking him up.
All right, you need to speak up a little more, please.
Yes, sir.
All right, that's better. Thank you. All right, now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to be here in court to testify for you, just like the state. So if you have any witnesses you want to testify, you're not certain will come voluntarily at your request. The court issues a subpoena, which is a court order, and that forces those people to come to court and testify for you if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court. You understand that?
Yes.
Right now, under the Constitution, you have a privilege against self-incrimination, and that means you can't be forced to testify against yourself in this case at any time, including the trial. No one can ever make you testify. The prosecutor can, the judge can. You make the decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one's even allowed to talk about it, except in one situation, that is if there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yeah.
Right now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. So the burden of proof isn't on you to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to provide any defense at all. You may, but you're not required to. Whether you do or not, the state will still be required to present evidence that proves to either the jury or the judge's satisfaction, depending upon which type of trial you want to have, of your guilt, a proof beyond reasonable doubt on every essential element of the defense charge, and that's the highest burden of proof that's known under the law. You understand that?
Yes, sir.
All right, now, Mr. Harrison originally pled not guilty, that plea denied the allegations in the indictment, not committed any crime, and exercised all of the rights that I just described. If you change your plea from not guilty to guilty, that's the opposite of not guilty plea. Guilty plea admits the allegation, the indictment admits that you committed those acts and that you're guilty of the offense alleged. That plea waives, gives up all of the rights that I just described for you, except your right to have an attorney, because you always have a right to have an attorney no matter what you plead. With that exception, your plea of guilty waives, gives up the right to have a jury court trial, waives, gives up your right to confront witnesses, initiate the cross-examination for your attorney, waives, gives up your right to use armed court, or court witnesses to come forward and testify for you, same as the state. Waives gives up your privilege against self-incrimination, because you say you're guilty, that's what you find you guilty. Waives gives up your presumption of innocence, because you say you're guilty, the state's not required. This subjects you to a sentence immediately by the court. And finally, a waive gives up any right to file an appeal, which you think may have up to this point in the case. Now, if I sent you the maximum sentence, or the certain to file an appeal, have to be filed within 30 days, your sentencing period being filed. You understand all that?
Yes.
And are you a U.S. citizen?
Yes.
And do you have any questions about the charge or the possible penalties?
No.
You understand?
Yes.
Do you have any questions about the intervention plan or anything that goes on with that?
No, I understand.
Any questions about the plea agreement?
No.
You understand it?
Yes.
Any questions about the constitutional rights of the claim?
No.
You understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, what the consequences of that would be if you enter that plea here today?
No.
You understand?
Yes.
Anything you'd like to speak to Ms. Berger about before we go any further?
No.
Is it your decision to withdraw your not guilty plea and plead guilty to the charge of, what is that? Firearm?
To the fire alarm system.
Is it your decision to withdraw your not guilty plea and plead guilty to the charge in exchange for being placed in the intervention program according to this plea agreement which is gone over?
Yes, sir.
Right, and answer the charge which alleges that on or about June 26, 2020, well, you know what, let me back up. I skipped over something. The charge alleges that on or about June 26, 2020, Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance, methamphetamine, in violation of Section 292511. Now, do you understand what it is you're charged with?
Yes, sir.
And if you discuss that charge with your attorney, the nature of it, the evidence in the case, possible legal issues, possible offenses you try to raise in trial, and possible outcome of the trial with your attorney?
Yes.
And are you satisfied with your advice and comments in this matter?
Yes.
Are you under the influence of any type of drugs or alcohol at this time?
Excuse me?
Are you under the influence of any kind of drugs or alcohol? You're not taking any prescription drugs?
No.
Has anyone threatened you in any way to get you to plead guilty to the charge?
No.
And other than the promise to be put into the intervention program, has anyone promised you anything?
No.
Okay. Now, it's your decision to plead guilty then?
Yes, sir.
All right, then if you would stand and answer the charge, which alleges that on or about June 26, 2020, Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, violation of Section 292511, Itemized Code 53 felony, carrying possible prison term between 6 and 12 months, fines up to $2,500, possible license suspension 6 months prior to your date.
Guilty.
Thank you, receipt. All right, the court finds that on this date of the court, defendant was advised of all his constitutional rights and made a knowing, intelligent, voluntary, rigorous, same percent pursuant to Rule 11. Please accept the court file. Defendant, however, is not found guilty now because he is eligible for the intervention program. Instead, the court will order that the proceeding to be stayed and no finding of guilt entered upon this time. And the court will hold the matter in advance until the court receives the report from the probation department regarding the defendant's progress in the program. It's ordered the defendant be placed into the intervention conviction program, and that court finds he's currently in an appropriate certified treatment program, is otherwise eligible for control, is not a repeated dangerous offender, and meets the criteria for intervention conviction as set forth in the statute. And that his drug dependence was a factor in leading this criminal activity and treatment will change or reduce the likelihood of that activity. The defendant is placed under control of the probation department in terms of the program adopted by the court for a period of 2 years. If required to successfully complete an intervention plan at another chance, including the requirement of abstaining from use of drugs or alcohol for a period of 1 year. All the conditions and terms that the probation department may require court's order. Then it's ordered to pay the court costs. Now, if the defendant successfully completes all of these conditions, then the court will dismiss the charge about to be set for a emergency of record. If the defendant fails to complete any of these conditions, comply with the conditions, then on written notice of the probation department to the defendant and the court, a hearing will be set. The defendant will be represented by counsel. The outcome of that hearing is a detailed complaint, and at that time, the court may find him guilty and imprison the defendant for a period of 6 to 12 months and fine him $2,500 and suspend his license for a period of 6 months to 5 years. All right, now that completes the hearing. We're now off of community control, and you'll see Mr. Archie immediately after the hearing. I should say you're off of pre-trial supervision, so you're not under house arrest or the conditions of that bond, which will be these new conditions. And you'll meet with Mr. Archie. Any further counsel?
No, Your Honor.
Mayor?
The only thing I want to say to you, Mr. Harrison, is the next time you appear in court of law, in front of this judge in this courtroom, don't wear flip-flops.
I apologize.
Okay, don't do it again. I overlooked it this time. Don't do it again. Hopefully I'll not see you again.
Right.
But if you do, okay. We have this 11:30, health department case and.
Yes, Your Honor.
It was dismissed.
Oh, no,
Sure.
you sure, that's right. Oh, wait a minute.
No, I think it's been dismissed.
Yeah, it was dismissed. Yeah. Just last week. Okay.
Okay, 1 o'clock.
Sorry. You just want to do it over the phone?
All right, are you, Ms. Beckman, there on the screen that says,
Actually, that guy.
yes, and,
Yes,
okay.
On the record for Buckelman.
All right, Mrs. Beckman. All right, this case number 1CR 214, State of Ohio versus, Kara. Beckman is appeared by Sue from, Wind Valley, Treatment Facility. Her attorney is William Armentrout. He's appearing also by, Sue. The prosecuting attorney, and Collins, is the attorney on behalf of the state as well. Armentrout, you and your client both agreed that this matter be conducted remotely by Zoom rather than having her transport back here to the hearing.
Yes, Your Honor.
I'm sorry?
Yes, Your Honor.
All right. And you're agreeing with that, Ms. Beckman?
Yes.
All right, thank you. All right, Ms. Beckman is under a plea of guilty to assault on a peace officer, 4-3 felony. Court ordered a pre-sentence investigation, and I have reviewed that and prepared to go forward. Anything from the state regarding sentencing?
Only, for the record, again, the officer involved in this did approve this plea agreement.
There's no restitution?
No.
Thanks. Mr. Armentrout?
Only, Your Honor, I would ask the court to follow the recommendation of the state and place Kara on community control. It's my understanding, Karen, correct me if I'm wrong, but there is a bed for you in a different facility for your continued treatment. Is that correct?
Yes, sir.
That's all, Your Honor.
All right, Ms. Beckman, anything you'd like to say?
Thank you for giving me the opportunity to get out of this mess here and try to start.
All right. Well, I have reviewed the report, and the order of the court that the defendant be is thereby sentenced to a term of 3 years of community control under the supervision and control of the Hudson County Probation Department under these conditions. Mr. Government, first of all, you obey all laws of all jurisdictions, conduct yourself in all light manner all time. Report when and as direct. You must be truthful in all statements that you make to your supervising officer and the questions you give to them regarding your condition, or any answer to questions that they ask you regarding the condition. You must keep them informed of your residence, place, and employment all the time, and not change out without prior permission. You must not leave the state of Ohio without prior written permission. You must have a copy of your pass with you at all times. You may not enter upon the grounds of any correctional facility, nor may you attempt to communicate with or communicate with anyone in those facilities without prior permission. Not permitted to purchase, possess, own, use, or have under control a firearm, ammunition, native, shorters, weapon of any other type. May not have, purchase, possess, use, or have under control any kind of controlled substance, drug abuse, CBD oil, kratom, or any varying or analog of those that may have similar effects, or any instrument, device, or thing that may be used to administer them or prepare them for administration, unless you have law restriction from any of such items. And if you do, you must provide a copy of that within 24 hours of receipt to the probation department. You are submitted to drug testing when and as directed. May not purchase, possess, use, or have under control alcoholic beverages, nor may be present in places where the sold or being consumed, even as otherwise lawful. You're not permitted to associate with anyone as a co-defendant in this case, or any other person who has the past, could future influence you to commit a criminal offense to violate these conditions, unless approved in writing by your supervising officer. After the date of this order, you're not permitted to marry, establish cohabitation, and a common law type relationship with another person without prior section. You must report any contact law enforcement or arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. You must report, or you must provide your supervising officer any financial information records so that your ability to pay fees and costs will be reviewed. If you are referred for assessment, evaluation by probation department for any additional treatment, counseling, training, etc., you'll submit to that. If there's any recommendation for programming, you must enroll in and successfully complete that. You're paid court costs and make payment arrangements to do that. Special conditions are you are successfully completed residential treatment and aftercare at the Lloyd Simmental facility. So I understand it's right there nearby, and you'll remain where you are until you remain there. Now once you do complete that, you are to report to the probation department immediately. You, by being placed under community control, are being consented to a search without a warrant of your person, your residence, vehicles owned by you, used by you. You are to be placed where you're located or found at any time by any officer of the probation department. Whoever's speaking, if you could use your microphone until we call your case, I appreciate it. Now, you're also paid court costs as a subject order. If you fail to do so, court then could order you to do service to you, credit for each hour you work, IRA assessment for each hour you work, reduce your judgment by that amount until paid in full. Now, in the event that is alleged that you have failed to comply with these conditions, a written notice of that will have to be filed. Court served upon you, and you'll be able to have a hearing. You're represented by counsel.
Yeah.
If the outcome of that hearing is that you have failed to comply, then at that time the court presents you a period of incarceration in the prison facility between 6 and 18 months, finding $5,000. That happens once you complete your prison term. Post-release control, as determined by the Adult Control Authority, is optional. If they decide that you should be under that, it will be for a period of no more than 2 years. And if during that period of time they find that you have failed to comply, they could return you to prison, even though you served the entire prison term set by the court, for an additional period of up to, in this case, half of your prison term for one or more violations. But if you committed a felony, then in addition to whatever sentence the judge in the new case could impose, that judge could also sentence you for that violation in this, while under post-release control in this case, for an additional period of 1 year, whatever time left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively sentence in the case. All right, is there anything further for counsel?
No, Your Honor.
Ms. Beckman, then you're off of pretrial supervision. You'll go to the treatment facility. As I said, once you're released from there, you'll need to get in contact with the probation department immediately. And they may be in touch with you before then. If they do, you'll need to provide that information. All right?
Okay.
Thank you. You go ahead and sign off. All right.
Aaron Taylor, Massey House.
Are you Aaron Taylor there appearing on Adam's screen?
Yes, sir.
All right.
On the record, Taylor.
All right, this is case number 21 CR 83, State of Ohio versus Aaron and Taylor. Mr. Taylor is appearing by Zoom from Massey House. His attorney is William Armstrong, appearing by Zoom from his office. Prosecuting attorney Collins is appearing from her office by Zoom. This hearing is being conducted by Zoom due to his being in a treatment facility as well as COVID-19 precautions. Mr. Armstrong, you and your client are both willing to make this hearing be conducted in person or remotely rather than in person.
Yes, Your Honor.
And you're in agreement with that, Mr. Taylor?
Yes.
All right. Mr. Taylor, since you're not present in the courtroom during this time, you need to talk to Mr. Armstrong. Let me know. I can put you and him into a breakout room where the two of you can talk privately. No one else will be able to see you or hear you. All right?
Yes, sir.
Mr. Taylor, in plea guilty to aggravated possession of methamphetamine and fifth-degree felony. Matter was referred for a pre-sentence investigation. I have received and reviewed that. Anything from the state regarding sentencing?
Only what's contained within the plea agreement, Your Honor.
All right. Mr. on traffic.
I would ask the court to follow the recommendation of the state and place him on community control. Since Aaron's been at Massey House, has been clean and sober. I've spoken with him there 2 or 3 times over the last 3 months, and as with any of these cases, you can see the improvement when they're clean and sober. I believe he's sincere about it, and we'd ask the court to follow the state's recommendation.
All right, Mr. Taylor, anything you would like to say?
I just want to move forward with that.
All right, it's a general on the courts that you be put, sentenced to a term of 3 years under the supervision of the Huntington County Probation Department. We require to comply with these conditions. First, you obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times. Report when and as directed, be truthful in all statements you make to them, as well as any answers that you give to them about questions they ask about your conditions. You must keep them informed of your residence and place of employment at all times, and not change either without prior permission. Not leave the state of Ohio at any time without prior written permission. You must have a signed permission slip with you when you do that. You may not enter upon the grounds of any correctional facility of any jurisdiction or communicate with anyone or attempt to communicate with anyone who's in any of those facilities without prior written permission. You may not purchase, possess, own, use, or have under your control any kind of arm, ammunition, dangerous orders, weapons of any other type. And because of this conviction, it's a violation of both federal and state law if you have any firearm or ammunition, dangerous orders. Unless you have a disability removed in the future proceeding, and that doesn't occur, you could be prosecuted for a felony. You're not permitted to purchase, possess, use, or have under your control any kind of controlled substance, drug abuse, CBD oil, kratom, or any variant or analog of those that has effects similar to controlled substances or drugs of abuse, or may have any instrument, device, or thing that may be used to administer them or prepare that administration must have a law prescription, a copy of which you must have presented to them within 24 hours from your receipt. You're submitted to drug testing when and as directed. You may not purchase, possess, use, or have under control any type of alcoholic beverage, nor may be present in places with sold, being consumed, even otherwise lawful. You may not associate with any co-defendant or any other person that has a criminal record, as a member of a gang or a criminal group, or any person that has a past or future approach to commit a criminal offense or violate these conditions, unless approved in writing by a supervised officer. You now, after the date of this order, to establish cohabitation and a common law marriage type relationship with another person without written permission. Must report any contact with law enforcement or any conviction, arrest, citation, or other charge for violating the law later than the next business day after that occurs. You're to provide the probation department with any financial information or records that request so that your ability to pay any fees or costs will be reviewed. If you're referred by your probation department or probation officer for any evaluation assessment for any further treatment or counseling or programming, you'll submit to that, and if there's a recommendation that you be engaged in other programming, and you're to roll in and successfully complete that. You're required to pay court costs, make payment arrangements with the clerk to do so. You're required to successfully complete the FRS treatment plan and aftercare. Now, by being placed on community control, rather than being sentenced to prison, you're deemed consented to search without a warrant on your person, your residence, your vehicles, or any other property or place where you're found that are under your control at any time, any officer of the probation department. There will be no fine imposed, there will be no license suspension imposed. You're ordered to pay the court costs as a condition, and it's also you're making payment arrangements for that as a condition. But if you fail to pay it, you're also ordered to pay it as a substantive order. And if you fail to comply, then the clerk will collect that through various means, including letting on bank account, wages, earnings, or other assets you may have. If that doesn't collect it, then the court will order you to do community service and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your credit by that amount to pay in full. Now, in the event that it's alleged that you have failed to comply with this, any of these conditions, the probation department will file a written notice of that with the court and serve a copy on you. You will be entitled to have a hearing and be represented by counsel. The outcome of that hearing is that you have failed to comply. At that time, the court will revoke your community control and sentence you to a prison term of between 6 and 12 months, fine you $2,500. If that happens, once you complete the prison term imposed by the court, under the law, the adult parole authority has an option to put you under close control supervision for a period of up to 2 years. If they do that, you supervise on the conditions they set. If If they determine that you are not compliant, they can return you to prison, even though you serve the entire term set by the court, for an additional period of up to 1/2 of your prison term for one or more violations. But if you violate by committing a felony, then in addition to whatever sentence the judge in the new case imposed upon you, that judge is also authorized to sentence you in this case for an additional period of 1 year, or whatever time left on to your imposed for whichever is greater. If that occurs, that must be served consecutively to the sentence again. All right, that completes the sentencing. You're no longer under pretrial supervision or under new conditions. As far as him, is he contact the probation department, or will they reach out to him?
I'll reach out to him or the Massey House.
All right, thank you. All right, anything further from council?
No, Your Honor.
All right, thank you. Sign off then, Mr. Taylor. Thank you. Okay.
Jail, Nichols.
All right, are you Rick J. Nichols there at the jail?
Yes, sir.
All right. Case number 18 CR 196, State of Ohio versus Rick J. Nichols. Mr. Nichols is appeared by Zoom from the jail.
2 cases, Your Honor.
And also, 20 CR 12 now. He's appearing by video from the jail, by Zoom, I should say, due to COVID-19 issues. His attorney, William Armstrong, is appearing in his office, and prosecuting attorney, Collins, is appearing in her office. Now, Mr. Armstrong, you and your client both agree with this matter to be conducted by Zoom rather than in person.
Yes, Your Honor.
You are agreeing with that, Mr. Nichols?
Yes, Your Honor.
All right. Well, since you're not in the courtroom with him, if during the time of this hearing you need to ask him a question or would like to talk with him about something, just tell me and we'll stop and let you do that, and then deal with another case when you're talking. You'll be put into a separate breakout room, which means just the 2 of you on the screen talking. No one else will be able to hear you, no one will be able to see you, you won't be recorded. Right? Now, in case number 18 CR 196, Mr. Nichols is charged with aggravated possession of methamphetamine, a 5th-degree felony, and in 20 CR 12, he's charged with failure to appear, a 4th-degree felony. And I believe that trial dates are set on October 14th. All right, now Mr. Nichols, I've been presented with plea of guilty form in each of these 2 cases, which indicates that you're going to withdraw your not guilty plea and plead guilty in both cases.
Yes, sir.
Now, these are 3-page documents that the prosecutor's office has prepared, and I'll hold them up to the screen just to confirm that you recognize these. First one is 18 CR 196. Can you see your name there and the plea of guilty form?
Yes, sir.
It's a little dark up here due to the weather conditions, so I apologize for that. Kind of gets lighter and then gets darker according to the sun. And this is 20 CR 12. You see that one?
Yes, sir. Yes.
Now, page 3 of each of these documents, there are signature lines, and right below a sentence that reads, "I enter this plea voluntarily." And so, in 20 or 18 CR 196, the aggravated possession of methamphetamine, it's near the top of the page, and right below that, there's a signature of the defendant, and I read your signature close to my hand, Rick J. Nichols. I believe that's your signature. Is that your signature that I've got there by my finger?
Yes, sir.
All right, and then at 20 CR 12, same sentence a little further down, and is that your signature right there?
Yes, sir.
When did you sign these documents, Mr. Nichols?
It was Mr. Armstrong, I think it was.
I believe it was yesterday.
Yeah, yesterday, yeah.
All right. Did he go over these with you before he signed them?
Yes, sir, he did.
Did he answer any questions you had and explain them to you?
Yes.
When you sign each of these documents, you understand it's an agreement to plead guilty, which means there won't be a trial in either case, and the next step in the cases would be a sentencing hearing.
Yes, sir.
And you feel you have enough time to fully consider this matter before making that decision?
Yes, sir.
Do you feel that you were rushed or pressured in any way in doing this?
No, sir.
And are you entering into the agreement to plead guilty in each of these cases voluntarily?
Yes, sir.
All right, now, on page 1 of the 18 CR 196, it says you're going to withdraw your plea, not guilty, plead guilty to the charge of aggravated possession of methamphetamine under section 2925.11 of the Higher Vice Code, 5th degree felony. In the states that you understand that the maximum penalty for that could be 12 months in prison, 6 months would be the minimum prison term imposed, could be a fine of $2,500, could be a license suspension 6 months to 5 years. You understand that?
Yes, sir.
Now, in 20 CR 12, it says you're going to withdraw your not guilty plea, plead guilty to the charge of failure to appear under 2937.99 in the Vice Code of 4th degree felony. In states you understand the maximum penalty for that could be 18 months in prison, minimum of 6, and the prison term imposed could be a fine of $5,000. You understand that?
Yes, sir.
Now, under the law, if you're convicted of both of these offenses, and if you should be sentenced to prison in both of those, the sentences that are imposed would order to be served consecutively, meaning one after the other. And so that means that with a maximum of 12 months in the aggravated possession charge and 18 months of the failure to appear, the total is 30 months, and the total fine is $7,500. You understand that?
Yes, sir.
Other than these two charges, are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control, or any felony offense in any jurisdiction?
No, sir.
All right, now, under the law, if you should be sentenced to prison and serve that prison term as imposed by the court, once you are released, the adult parole authority has the option, if they choose to exercise it, to put you under post-release control, meaning you can be supervised under conditions that they set for a period of up to 2 years. Now, if during that period of time you were being supervised, they felt that you were in town and you were not in compliance, they could return you to prison to serve an additional period as a sanction up to 9 months for one violation, but there is a cap or limit of half of whatever prison term is imposed for all violations. But if you commit a new felony, then in addition to whatever sentence the judge adjudicates imposed upon you, that judge could also sentence you in this case to an additional period of 1 year or whatever time is left on the 3 year post-release control, whichever is greater. And if that occurred, that would have to be served consecutively with the sentence in the new case. Do you understand that?
Yes, sir.
Under the law, I'm not required to sentence you to prison for any of these offenses. I can impose what's called community control or probation. That means instead of going to prison, you can be supervised by a probation department officer under the term set by this court for a period of up to 5 years. Now, if during that period of time you're being supervised, probation department felt you were not compliant, then they would file a written notice of that with the court, serve a copy upon you, and you would be allowed to have a hearing and be represented by an attorney. If the outcome of that hearing was that you failed to comply, then at that time the court would revoke community control and sentence you to 30 months and fine you $7,500. You understand that?
Yes, sir.
All right, now the charge in case number 18196 alleges that on or about August 18, 2018, Huntington County, Ohio, you did not obtain, possess, or use Schedule 2 controlled substance with methamphetamine. And that's the 5th degree felony, penalties which I explained to you a moment ago. In case number 20 CR 12, the indictment alleges that on or about December 17, 2019, Huntington County, Ohio, you did recklessly fail to appear as required in Huntington County Common Pleas Court case number 18 CR 196. After being released, having been released pursuant to ORC 2937.29, and released was in connection with the charge of commission of felony in violation of 2937.99 of the Vice Code. That's the failure to appear charge of 4th degree felony.
Yes, sir.
Now, Mr. Nichols, do you understand what it is you've been charged with in each of those cases, what the state said you did, when, where, how, and alleged did?
Yes, sir.
You discussed the nature of each charge, the evidence in the case, possible legal issues in the case, possible offenses might try to raise a trial, possible outcomes of a trial with your attorney.
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Has anyone threatened you to get you plead guilty here today?
No, sir.
Now, on page 2 of each document, there are a couple of lines printed in bold and underlined towards the lower portion of page 2, and it reads as follows in 18 CR 196. Defendant shall plead guilty, Governor plead guilty to the indictment. State defense shall not recommend community control, substance abuse treatment, and actually the same sentences in both agreements. Now, is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the matter of sentence is reserved to the judge, not the parties. So even though there's an agreement that you should get community control to plead guilty, I'm not bound by that agreement. So once I've heard all the information submitted to me and considered it regarding the matter of sentence, if I decide that's not the correct sentence, I could go ahead and send you to prison for $30, fine $7,500, and suspend your license for 6 months to 5 years. You understand that?
Yes, sir.
You hold any license or certificate from any state agency for any profession or occupation?
No, sir.
Right now, under the law, you have certain rights to understand before I can accept the plea guilty from you. First, you have the right to counsel. Armed Travis is appointed representative in these cases. This appointment wasn't simply for the purpose of working the cases out, but to provide any defense to you that could be available under the law which you would like to provide. So if you decide you do not want to plead guilty in either of these cases, he can still represent you, defend you, including a trial if that's what you want. You understand that?
Yes, sir.
Now, in the Constitution, in each of these cases, you have the right to have a jury trial in which 12 people will be selected from a group of citizens that are summoned for jury duty on their trial day. After they are selected, the evidence will be presented, and then that jury will decide whether or not the state proved your guilt by proving beyond a reasonable doubt on all of the elements of each of the offenses. Now, and that would have to be a unanimous verdict, meaning all 12 would have to agree. Now, if you didn't want to have a jury trial, but you did want to plead guilty, you could waive in writing, which means give up your right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning that the judge would be the one to hear the evidence instead of the jury. The judge would apply the law, the judge would decide whether or not the state proved your guilt or proved beyond a reasonable doubt. You understand that?
Yes, sir.
Right now, in the Constitution, in each of these cases, you have rights to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into the court and testify in front of you and anyone else is present. After the prosecutor will be asking questions, then your attorney will have the right to ask questions. That's called cross-examination. The purpose of that would be to bring out evidence and help your side of the case. You understand that?
Yes, sir.
Right. Now, under the Constitution, you have a right in each of these cases to use the power of the court to compel or force witnesses to come to court and testify for you, just like the state. So if you have any witnesses you're uncertain are going to come in voluntarily, you request a court order as a subpoena. And that will force those persons that you name to come to court to be able to testify, even though they don't want to be here. Which is the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Right now, in each of these cases, you have the privilege of self-determination, meaning you can come to court to give evidence at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. In fact, no one's allowed to talk about it except with one exception, that is the jury trial. You do not testify. The judge instructs the jury that because that's your constitutional right, they do not consider it for any purpose. You understand that?
Yes, sir.
Right now, originally you pled not guilty. I'm sorry, one more. Under the law, you're presumed innocent of each of these charges that prove guilty by the state of Ohio, every essential element of each offense. What that means is that the burden of proof isn't on you to try to prove you're not guilty of either charge. The burden's on the state. And so you're not required to even present any evidence in your defense at trial. And you may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt on each of these offenses by proof beyond a reasonable doubt on every essential element of each charge, which is the highest burden of proof is known in the law. You understand that?
Yes, sir.
Now, originally you entered a plea not guilty to both charges. That plea denied the allegations in each indictment, denies you committed any crime, and exercised or invoked all the rights that I just described. Now, if you change your plea from not guilty to guilty, that is the complete opposite of not guilty plea. Guilty plea admits allegations, admits that there are a crime that you're the one who committed that crime. That plea raises up all the rights I just described for you today, except the right to have an attorney, because you always have a right to have an attorney no matter what you plea. But with that exception, your plea of guilty, Wage gives up your right to have a jury or court trial. Wage gives up your right to confront the witnesses and cross-examine through your attorney. Wage gives up the right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. Wage or gives up the privilege against self-incrimination, because you're the one saying you're guilty, that's what you find you guilty. Wage gives up your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, Wage gives up any right to file an appeal that you think you may have had at this point in the case. Now, if I should, excuse me, if I should sentence you to the maximum sentence, or under other certain circumstances, you can file an appeal. Any appeal that you were to file would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
All right. Do you have any questions about the charge or the possible penalties in either case?
No, sir.
Do you understand?
Yes.
Do you have any questions about the plea agreement?
No, sir.
Do you understand?
Yes, I understand.
Again, you understand that the recommendation as to sentencing is not binding on the court.
Yes. Yes, sir.
Now, do you have any questions about the constitutional rights that are explained to you?
No, sir.
You understand those?
Yes, I understand.
All right. Do you have any questions about the plea of guilty, what it means, what will happen if you know that plea here today?
No, sir.
You understand?
Yes, I understand.
All right. Is there anything you'd like to speak with Mr. Martin Trapp before we go any further?
No, I should be good. I think we're all right.
Do you have any questions?
No, that's fine.
All right. Then it's your decision, Mr. Nichols, to withdraw your not guilty plea in these two cases and plead guilty to both of them pursuant to the agreements that we've just gone over.
Yes, sir.
And in case number 18 CR 196, which alleges on or about August 18, 2018, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, violation of Section 2925.11 Higher Vice Code, 53 felony, carrying possible prison term 46 to 12 months, fine of up to $2,500, possible license suspension 6 months to 5 years. How do you plead?
I plead guilty, sir.
And case number 20 CR 12, which alleges on or about December 17, 2019, Highland County, Ohio. You did recklessly fail to appear as required in Highland County Police Court, case number 18 CR 196. And after having been released pursuant to ORC 2937.29, and released with the connection with the charge of commission of felony, violation section 2937.99, failure to appear, a fourth degree felony, carrying possible prison term 26 to 18 months, fine $5,000. How do you plead?
I plead guilty, sir.
All right, the court finds on this day, oath of court, defendant provides all the constitutional rights to make no income from voluntary waiver of the same. Sentence number 11, please accept this order filed. In each case, defendant is found guilty. In case number 18 CR 196, is found guilty of aggravated possession of methamphetamine, a fifth degree felony, charged therein. In case number 20 CR 112, he is charged, or he is found guilty of failure to appear in fourth degree felony, is charged therein. Court orders the matter be referred to the probation department for a pre-sentence investigation, which will include an assessment for substance use disorder treatment as well as mental health. I think that's already been done. I see there is a head available for him tomorrow at Counseling Center. Is that correct, Mrs. Sturgeon?
Yes, sir. We've arranged for transportation if the court will allow.
All right. And is that the west facility in Adams County?
It will be determined when he gets there. He would go to the intake and fly out, and then they would put him in the house out of bed.
All right. Well, the court then will set the sentencing hearing for November the 18th at 1 o'clock. Now, the bond will be continued with the modification that it will be an OR only on condition, effective tomorrow, on condition that he enter in and remain in the treatment program at the counseling center during the pendency of this action. And so if you walk away, it's not a lockdown facility. If you walk away, then that'll be a violation of your OR bond, Mr. Nichols, and will certainly have an impact on whatever sentences you get if you walk away and don't come back voluntarily. All right. So I'll prepare an entry and we'll have to go there tomorrow. All right. Anything further, counsel?
No, Your Honor.
All right. Thank you.
Dalton Boyd, Mr. Wagner.
All right. Who is it?
Dalton Boyd.
All right. Dalton Boyd.
Mr. Wagner.
Thank you, Your Honor. Yes, Mr. Boyd.
Oh, man. All right. Are you Dalton James Boyd?
Yep, yes, sir.
Recording in progress.
All right. This is case number 21 CR 31, State of Ohio versus Dalton James Boyd. Mr. Boyd is appearing by video, by Zoom from the Justice Center due to COVID. His attorney is James Wagner, I believe. Mr. Wagner is appearing by Zoom, and representing the state is a prosecuting attorney office. Now, Mr. Wagner, you and your client both agree that this matter to be conducted by Zoom rather than in person appearing before the court.
Yes, sir, Your Honor.
You're all right with that, Mr. Boyd?
Yeah.
Okay, yeah. Keep your voice up, please.
I'm sorry.
No problem. Now, Mr. Boyd, since you're not present next to your attorney in the courtroom or in a jail, you need to talk to him at any time, ask him any questions, or discuss something with him. You just tell me, and I can put you and him in what's called a breakout room, which means just the two of you on the screen, talk to each other. No one else will be able to see you or hear you. You won't be recorded, okay? All right. Mr. Boyd is charged with failure to comply with the order or signal of a police officer and aggravated possession of methamphetamine, 5th degree felony. The matter is set for trial on November the 8th. Now, I've been presented with a plea of guilty form, Mr. Boyd, which indicates that you're going to withdraw your not guilty plea and plead guilty to the charge. This is a 3-page document that the prosecutor's office prepares from the form in her computer, and then they print it out and put it in, after they put in the information about your case. And I'll hold this up to you and see if you, to the camera, if you recognize this being your case and the plea of guilty form.
Yes, sir.
On page 3, there are signature lines. Right below a statement or a sentence that says, I enter the plea voluntarily. Immediately below that, there's a line, what appears to be signature with a little X next to it that says Dalton Boyd. I'll hold that up to the camera and ask you if that is, that is your signature there that you're looking at there.
Yeah, that's mine.
When did you sign this document, Mr. Boyd?
The last time we talked to him, I think.
Probably a couple weeks ago, Your Honor.
Okay. And, were you at the jail with Mr. Wagner when you signed it?
Yes, sir.
Did he explain everything to you and answer any questions you had about it?
Yes, sir.
And do you think you had enough time to fully consider that, before making that decision?
Yes, sir.
Is this what you still want to do?
Yeah.
Are you entering into the agreement voluntarily?
Yeah.
All right, now the agreement states on page 1, if you're going to withdraw, you're not guilty, plead guilty to count 1, failure to comply to order signal police officer, or 2921.331B, a third-degree felony. Further states that you understand that the maximum penalty for that offense could be 36 months in prison. There's a minimum of 9 months if the prison term is imposed. There's a fine available of up to $10,000 and a mandatory license suspension of between 3 years and life. You understand that?
Yes, sir.
Now, are you facing any felony charges in any other jurisdiction?
Yes, in Pike County.
Pike County?
Yes.
And is that a felony?
It's felony.
Okay. Well, if you're convicted in both this county and Pike County, and if you're sentenced to prison in both cases, then those prison terms could be ordered to be served consecutively, meaning one after the other. You understand that?
Yeah.
Right now, under the law, well, let me ask you this, are you under community control, probation, post-release control, or parole for felony from any jurisdiction?
Yes, sir.
Under the law, Mr. Boyd, if you're convicted of this offense and sentenced to prison, once you complete the term set by the court, the adult parole authority could decide at their option which one was called post-release control for a period of up to, in this case, 3 years. No, I'm sorry. Is a minimum of, okay, you will be under post-release control for a minimum of 1 year and a maximum of 3 years. So you have to be on PRC, but the range is at least 1 up to 3, as determined by the adult parole. Now, during that period of time, if you violate any conditions that they impose, they have the right to return you to prison. Make you serve as a sanction for that violation, an additional period of 9 months for one violation of the maximum of half of the prison term for all violations. But if you commit a new felony, then in addition, whatever sentence the judge, in a new case proposed upon you, the judge could also sentence you to an additional period, in this case, of 1 year, whatever time left on the period of post-release control, whichever is greater. That period that had to be served consecutively the sentence in the new case. You understand that?
Yes, sir.
Now, under the law, I don't have to sentence someone to prison for this offense. I can impose what's called community control sanctions, which means that instead of being sent to prison, you would be put under the supervision of a probation officer for a period of up to 3 years. I'm sorry, up to 5 years, under terms set by the court. If during that period of time they determine, or in their opinion, you were not compliant, they would file a notice of that to the court, serve a copy on you, and you would have a hearing. You'd be entitled to be represented by an attorney in that hearing to test that. If the outcome of the hearing is that you were in violation, at that time the court would revoke community control, sentence you to prison for 36 months, fine you $10,000. You understand that? Okay, you need to speak up.
I understand.
Okay. I can see you nodding your head, but I need to have your voice as well. All right. Now the charge in count 1 alleges that on or about August 30, 2020, in this county, you did operate a motor vehicle as defined in the ORC section 4501.01, so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle by the offender causes substantial risk of serious physical harm to person or property, in violation of section 2921.331D of the Iron Vice Code. So that's the charge, the plea eluding, or well, I usually call that called failing to comply with order signal police officer, 3rd degree felony. Now, Mr. Boyd, do you understand what it is you've been charged with, what the state says you did, when or how alleged you did it?
Yes, sir.
You understand the possible penalties for the offense?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, possible offenses might try to raise a trial, possible outcomes of the trial with your attorney?
Yes, sir.
Are you satisfied with this advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
Now, on page 2, toward the bottom of the page, there are 2 lines that are printed in bold, and then there's actually a couple of sentences, 3 sentences. The last one is stricken out because it offers different alternatives. So what's stricken out doesn't apply. So I'll read what does apply. Defendant shall utter plea guilty to count 1, state and dismiss count 2. State and defense jointly recommend 18 months incarceration. Is that your understanding of the agreement?
Yes, sir.
Then we want to do anything other than that, you should plead guilty here today.
Yes, sir.
Under the law, void matter sentences reserved to the judge, not the party. So even though there's an agreement as to what the sentence ought to be, once you plead guilty, and I've heard all the information submitted, if I decide that's not the correct sentence, I could impose a greater sentence of up to 36 months, fine $10,000. And also, I do have to sentence you to at least a 3-year suspension that could be up to life. You understand that?
Yes, sir.
Now, do you hold any license or certificate of any state governmental agency or any kind of a trade or occupation?
No, sir.
All right. You have constitutional rights you have to understand before you accept a guilty plea. First, you have a right to have an attorney. And Mr. Wagner's appointed to represent you, not simply to work the case out, but to provide any defense that might be available to you under the law that you wish to provide. So, if you do not want to plead guilty, he will still represent you throughout the remainder of this trial, or this case, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that were summoned for jury duty from this county, that live in this county on the trial. After those 12 persons were selected, the evidence would be presented that would be instructed on the law, and that jury would decide by unanimous verdict, meaning all 12 of them have to agree on a verdict as to whether or not you were proved guilty by the state. Now, if you decide you don't want to have a jury trial, but you don't want to plead guilty, you can waive the right, which means you give up the right to have a jury trial. And in that case, you would have to call a court or bench trial, which means that instead of the jury hearing the evidence, it would be the judge who would hear the evidence. The judge would apply the law, and the judge would decide whether or not the state proved you guilty by proving beyond reasonable doubt. You understand that?
Yes, sir.
All right. Now, under the Constitution, you have a right to confront witnesses against you and cross-examine them through your attorney. So what that means is, witnesses against you have to come into court and testify in front of you and your attorney and anyone else may be present. After the prosecutor is done asking questions, your attorney asks questions, that's called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court, testify for you, testify for the state. So if you have witnesses you're not certain going to come in voluntarily, you request for you to subpoena, which is an order, and that forces them to come to court and testify for you if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court and testify. You understand that?
Yeah. Yes, sir.
All right, now under the Constitution, you have the privilege against self-incrimination in this matter. Mr. Boyd, which means you cannot be forced to give evidence or testify at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. And no one's even allowed to talk about it, except in one situation, that is if there's a jury trial, you do not testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right, now under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of this offense. What that means is that the burden of proof is on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence in your defense. You may, but you're not required to, but whether you do or not, the burden of proof remains upon the state to prove your guilt on every essential element of the offense charged by proof beyond reasonable doubt, which is the highest burden of snow on the wall. You understand that?
Yeah.
Mr. Boyd, originally you entered plea not guilty. Not guilty denied the allegations, denied you committed any crime, exercised or revoked all the rights that I just described. If you change your plea from not guilty to guilty, that is the opposite of not guilty. If you guilty plea admits the allegations in the indictment, admits that they're a crime, you committed the crime. And that plea waives or deduct all the rights that I just described for you today, except the right to have counsel or an attorney. You always have a right to an attorney no matter what your plea is. With that exception, plead guilty waives gives up the right to have a jury court trial, waives gives up the right to confront witnesses to cross-examine your attorney, waives gives up the right to use the power of the court to compel or force witnesses to be in court and testify for you just like the state, waives gives up your privilege against self-determination because you're saying you're guilty, that's what you find you guilty, waives gives up your presumption of innocence because if you say you're guilty, they don't have to prove you guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal you think you could have to this point in the case. Now, I sent you the maximum sentence, under certain circumstances you file an appeal, that would have to be filed within 30 days for sentencing after being filed. Do you understand all of that?
Yes, sir.
Are you a U.S. citizen, Mr. Boyd?
Yes, sir.
Do you have any questions about the charges and possible penalties?
Yes, sir.
You understand it?
Yeah.
Have any questions about the plea of guilty, what it means, what will happen if you enter that here today?
Not really.
You understand that?
Yeah.
You understand the plea agreement?
Yes, sir.
Any questions?
Yes, sir.
You understand that the recommendation is not binding on the court?
Yes, sir.
You have any questions about the constitutional rights that explained to you?
Yes, sir.
You understand those?
Yes, sir.
Anything you need to speak to your attorney about before we go any further?
I don't think so.
You have any questions about anything I've explained to you today?
Just wondering why we're going to prison.
I'm sorry?
But wondering why we're in prison.
I don't know, that'll be up to the sheriff. I'm sure they'll get you there as soon as they can. That'll be up to the sheriff. I don't know what the schedule is. They have to book time to take you to prison now, so I know they have some booking Friday. I don't know if we'll go Friday, it'll be next week. Can't tell you. Anything else?
Yes, sir.
All right, then is it your decision to withdraw and not plead guilty to the charges just not over this plea agreement?
Yes, sir.
Then as to count one, which alleges that on or about August 30, 2020, in Huntington County, Ohio, you did operate a motor vehicle as defined in ORC section 450101, so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop. The operation of the motor vehicle by the offender causes substantial risk of serious physical harm to person's property. In violation of section 2921.331B of the Ohio Revised Code, charged failure to comply with order signal of a police officer, a third-degree felony carrying a possible prison term between 9 and 36 months, and provided by law, a fine of up to $10,000, a mandatory license suspension of at least 3 years to life. How do you plead?
Yeah.
Right, the court finds that in this date open court, defendant provides all his constitutional rights. Made knowing, intelligent, voluntary waiver, same pursuant to criminal 11. Plea is accepted, order filed, defendant found guilty of count 1 as alleged in the indictment, a third-degree felony. Count 2 was dismissed. Inasmuch as there's no request for a pre-sentence investigation, the court will not order one. Furthermore, there is a joint recommendation to sentencing, so the court will proceed for the sentence. Anything from the state?
Only what's contained in the plea agreement.
Mr. Wagner?
Mayor, we would only ask the court to go along with this plea offer, plea agreement. Again, my client was actually set the first pre-trial interim plea here. He accepts and acknowledges culpability 100%, Your Honor. So again, this was just simply waiting to get some paperwork finished before we're ready to plead out, Your Honor.
All right, do you have anything you'd like to say, Mr. Boyd?
No, sir.
All right, it's a judgment of the court that you be and are hereby sentenced to the Correctional Reception Center around Ohio for a period of 18 months. For the sheriff, we have 45 days of jail time credit from August 31st to September 8th. You were in, that's 9 days, you were in a sentence, in for a sentence for this work. So your credit is from actually September 1st up until today, which would be 36 days. Well, wait a minute. Now, okay, you're also entitled to additional 9 days, so a total of 45 days of jail time credit. Now, on completion of the sentence of Mr. Boyd, it is mandatory that you be put under the post-release control supervision of the adult parole board in the term they set for at least 1 year and up to 3 years. The maximum, and if during that period of time they determine that you fail to comply, they can return you to prison, make a certain additional period of up to 9 months for one violation or more, but it will be a cap of 9 months for all. But if you commit a new felony during that period of time, then in addition, whenever sentence the judge in a new case can impose upon you, the judge can also sentence you in this case to an additional period of 1 year, whatever time is up on that 3 years, post-release control, whichever is greater. That occurred, that would have to be served consecutively with sentence in the case. Your license is ordered to be suspended for a period of 3 years, beginning today. You will also be required to pay the court costs, which doesn't grant an execution order. If you fail to do that, then the court authority will give you service once you're released from prison in this county, while you're in prison, and will give you credit for charity work in an hourly rate set by the court. Charity work reduce your credit by that amount until they go. All right, is there anything further, counsel?
No, Your Honor.
All right, remain in custody, Mr. Boyd.
Mr. Wagner, could you stop by and sign the entry?
I will on my way to the courtroom.
Thank you.
Randy Swisher.
All right, Randy Swisher is next. All right, are you Randy J. Swisher?
Yes, sir.
All right, so it's case number 21 CR 88, State of Ohio versus Randy R. J. Swisher. This hearing is being conducted by Zoom. She's preparing from the Justice Center. I believe she's returned from the institution for today's hearing. And the hearing is being conducted remotely by Zoom due to COVID-19 issues. This Catherine Hamner is the attorney for the defendant. She's preparing from her office, preparing from the prosecutor's office, Prosecutor Collins representing the state. This Hamner, you and your client both stipulate this matter being conducted by Zoom remotely rather than being brought up here for an in-person hearing.
Yes, Your Honor.
You agree with that, Ms. Swisher?
Yes, sir.
All right, now Ms. Swisher, since you're not in court next to your attorney, if you have any questions at any time, please let me know. I'll put you in what's called a breakout room, which means it'll be just you and her on the screen talking to each other. No one else will be able to hear you or see you when you won't be in court. Okay?
Yes, sir.
All right, now Ms. Swisher is charged with looks like 4 counts, 2 counts of aggravated trafficking and 2 counts of aggravated possession of methamphetamine, third-degree felonies. This matter is set for a trial. Let's see.
Next Thursday.
Yeah, October 14th. Now, Ms. Swisher, I received a plea of guilty form, which is a 3-page document that the prosecutor's office prepared based upon the information that's relevant to your case. And hold up to the camera the front page and see if you recognize your name and case number there. Is that plea of guilty form?
Yes, sir.
All right, on page 3, there are signature lines right below a sentence that reads, I entered this plea voluntarily, and it appears to me the signature right below that is Randy Swisher. And I'll hold that up to the camera and ask you to identify that as your signature.
Yes, sir.
And when did you sign this agreement, Ms. Swisher?
This afternoon.
And did you sign there in jail with Ms. Hapner being present?
Yes, sir.
And did she go over that form with you and explain any questions you were explaining and answer any questions you might have had?
Yes, sir.
And when you signed that agreement, you understand it's an agreement to plead guilty, which means it's not going to be a trial. The next step in your case would be a sentencing hearing.
Yes, sir.
You feel you had enough time to fully consider this matter before making this decision?
Yes, sir.
Do you feel that you were pressured or rushed in any way?
No, sir.
Are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
Right now, the agreement states on page 1 that you're going to withdraw your non-guilty plea, plead guilty to count 1. Aggravated trafficking and methamphetamine of 2925.0381 Revised Code, a third-degree felony. From the states, you understand that the maximum prison term for that could be 18 months, 36 months, minimum would be 9 months. There would be a fine available of up to $10,000, mandatory fine of $5,000, and a possible license suspension 6 months to 5 years. Do you understand that?
Yes, sir.
Now, other than the charges in this case, are you facing any felony charges in any other jurisdiction?
No, sir.
Right, and are you on probation control, community control, or post-release control from any jurisdiction?
Not at this time. Once I'm released from prison, I will be.
Right, and you are serving a term for what? Why are you in prison now?
Claremont County, it's for a possession charge.
What, possession?
Possession, yes, sir.
And
I have a mandatory sentence.
I'm sorry?
A mandatory sentence,
Okay, how long?
3 years.
All right. If you are convicted in this offense, in this case, and sentenced to prison, the court could order that to be served secondly to the sentence in the other case. You understand that?
Yes, sir.
Okay. Now, once you, if you are convicted of this offense and sentenced to prison, once you complete that term, it is possible that the adult parole authority may decide to put you under post-release control supervision for up to 2 years, which means you can supervise on the terms they set by a parole officer. If they determine that you fail to comply, they could return you to prison, make you serve an additional period of up to 9 months for one violation, but there is a cap of whatever prison term is imposed for all violations, but if you've been a new felon. And in addition, whatever sentence the judge in the new case imposed upon you, that judge could also sentence you for committing that offense along with post-release control in this case. To an additional period of 1 year, or whatever time left on that period of post-release control. 2 years, 3 years. No, 2 years, sorry, I just changed it. This is an old form, isn't it? Yeah, because it has.
Probably, we sent an email and asked all the people that had forms from prior to
I'm gonna
be
change it,
voted.
it has 3 years, I'm gonna change it to 2, that's why I got confused. Yeah, so it would be 2 years would be maximum. And that would be served in the second, it would be 2 years or whatever time left, it'd be 1 year or whatever time left of the 2 years of post-release control, whichever is greater. And if that occurred, then that would be served secondly to the sentence in the new case. You understand that?
Yes, sir.
Yeah, the law just changed on the 30th of September, and all these agreements were prepared back before that happened. All right, now under the law about required to sentence you to prison and impose community control, which means that instead of going to prison, you can put under the probation department supervision for up to 5 years under terms set by the court. If during that period of time they determine their judgment that you were not compliant, they would file a written notice at the court. You would be entitled to have a hearing, you can have an attorney to represent you. The outcome of the hearing was that you failed to comply, and at that time the court could revoke the community control attorney or make you serve then at that time a sentence of 36 months, fine $10,000. You understand that?
Yes, sir.
Now, the charge alleges that on or about November 4, 2020, in Highland County, Ohio, that Red R. Swisher, you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance, an amount equal to or exceeding bulk amount, less than 5 times bulk amount, violation section 2925.03 A1 of the Revised Code, and that is the charge of third-degree felony. Now, do you understand what it is you're charged with, what the state says you did, when, where, how, the alleged did it?
Yes, sir.
Do you understand the possible penalties for that offense?
Yes, sir.
Have you discussed the nature of the charge, the evidence of the case, possible legal issues of the case, possible defense you might try to raise in trial, possible trial with your attorney?
Yes, sir.
Are you satisfied with your advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Today's recommendation you plead guilty here today.
No, sir.
Right now on page 2, a little over halfway down, there are several lines, looks like 4, that are printed in bold and underlined. Part of those have been stricken out, which would indicate they don't apply. Then there's some other language written in there in ink. So let me read it as I understand how it should read. Defendant shall enter a plea of guilty to count 1, state will dismiss the remaining counts, state defense will argue sentence. Defendant agrees to pay back my money as part of the plea agreement as follows: $625 joint several with red arsenal. Is that your understanding of the agreement?
Yes, sir.
Is that your understanding as well, Ms. Hammond?
It is, Your Honor.
Now, Ms. Swisher, has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
No one's promised you that if you plead guilty, you'll get any particular sentence.
No, sir.
Now, do you hold any license or certificate from any state governmental agency for any occupation or profession?
No, sir.
Okay. You say no?
No, sir.
Okay, thank you. Now, under the law, you have certain constitutional rights, as I understand, before I can accept a plea from you. First of all, you have a right to have counsel that's after been appointed to represent you, not simply to work the case out, but provide any defense that might be available to you under the law that you wish to provide. So if you decide you don't want to do this, then she will continue to represent you and defend you, including a trial, if that's what you want. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of Highland County citizens that were summoned for jury duty on your day of trial date. After they were selected, evidence would be presented, and then they'd be instructed on the law. And that jury of 12 would have to decide on a unanimous verdict, all of them have to agree whether or not the state proved your guilt or not proved you unreasonable doubt. Now, you didn't want to have a jury trial, but you did not want to plead guilty. And you can waive the right, which means to give up the right to have a jury trial, and in that case, you would have to call a court bench trial, meaning it would be the judge would hear the evidence instead of the jury. The judge would apply the law, the judge would decide whether or not the state proved your guilt by proving you unreasonable doubt. You understand that?
Yes, sir.
Right now, in the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court, testify in front of you, your attorney, and everyone else is present. After the prosecutor done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that would be to bring out evidence of health for your side of the case. You understand that?
Yes, sir.
All right. Now, under the Constitution, you have a right to compel witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain come in voluntarily at your request, the court issues a court order, subpoena, and that forces those people to come to court to testify if one of the two, though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify, now, used against you in any way by any person at any time in the proceedings. And in fact, all the people can comment about that, except in one situation, that is if there's a jury trial, you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, in the Constitution, Ms. Swisher, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is that the burden of proof is not on you to try to show you're not guilty. The burden is on the state to prove that you are guilty. So during the trial, you don't have to present any evidence of your own offense. You can, but you're not required to, whether you do or not. The burden of proof remains on the state to prove your guilt, prove beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that can be known under the law. You understand that?
Yes, sir.
Right, now originally entered a plea not guilty plea, denied the allegations in the indictment, denied you committed any crime, and it exercised or revoked all the rights that I just described for you. Now, if you change your plea from not guilty to guilty, it is the opposite of not guilty plea. Guilty plea admits the allegation that the indictment admits that they're a crime, that you committed that crime. That plea waives, gives up all of the rights that I've described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what your plea is. With that exception, your plea of guilty, waives, gives up the right to a jury or court trial. Waives, gives up the right to confront witnesses against you and cross-examine them through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to be here to testify for you, just like the state. Waives, gives up your privilege against self-incrimination, because if you say you're guilty, that's what she finds you guilty. Waives, gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, waives, gives up your right to file an appeal of any alleged violation of your rights you think could have happened up until this point in the case. Now, if you're sentenced to the maximum sentence, or under certain limited circumstances, you can file an appeal, but that would have to be filed within 30 days of your sentencing to be filed. You understand all of that?
Yes, sir.
Are you a U.S. citizen, Ms. Swisher?
Yes, sir.
All right, now, do you have any questions about the charge and possible penalty?
No, sir.
You understand them?
Yes, sir.
Do you have any questions about the plea agreement?
No.
You understand them?
Yes, sir.
Do you have any questions about the constitutional rights of the complaint?
No, sir.
You understand?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand?
Yes, sir.
Is there anything you would like to speak to Ms. Hapner about before we go any further?
No, sir.
Then is it your, do you have any questions about anything I'm going to ask you here today?
No, sir.
Then is it your decision to withdraw your not guilty plea, plead guilty to the first count, pursuant to the terms of the agreement we've just gone over?
Yes, sir.
All right, then as to the charge in count 1, which alleges that on or about November 4, 2020, Hyden County, Ohio, Brett R. Swisher and you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance in an amount equal to or exceeding bulk amount, less than 5 times bulk amount, in violation of section 2925.0381, charge of aggravated trafficking methamphetamine, a third-degree felony, bearing possible prison term between 9 and 36 months, in increments provided by law, a fine of $10,000, a mandatory fine of $5,000, a possible license suspension 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds that on this date, open court, defendant was advised all the constitutional rights made no intelligent voluntary waiver, same pursuant to Rule 11. Please accept and order by defendant found guilty of count 1, a third-degree felony, is charged therein. Counts 2 to 4 are dismissed. All right, as much as the defendant is already serving a prison term, I take a quick look at the discovery. It appears that she has previous convictions. I don't see any point in over an recent investigation, so we'll go ahead and hear arguments at this time. Ms. Foster.
Your Honor, we would ask the court to sentence the defendant to a term of incarceration of no less than 24 months. We would note that she is serving a current prison term. We would also note that nature of these charges are trafficking, not just mere possession charges. CI was used to purchase methamphetamine from the defendant and from her husband. And we would note that these are F3s, which means that they were in bulk amount each time. So based on all of that, we would ask the court to sentence the defendant to a term of no less than 24 months. Thank you.
And the restitution is owed to whom?
The task force, Hyden County Task Force.
Ms. Hacker, you have the defendant.
Thank you, Your Honor. Your Honor, the co-defendant is her husband, Brett Swisher. She was charged with 4 counts. He was charged with 6 counts. He pled guilty to more than 1 count. He was, I believe, he was granted community control. And they have, both of them have similar previous records. Neither of them are clean. They both have a fairly significant criminal history. We don't believe that she should be treated any differently than he is. He was granted community control. We believe she should be also. Obviously, she's going to be spending the next couple of years in prison, and she's going to have 3 years of mandatory PRC upon her release. So we do believe that that is adequate supervision for her, and that she should be given the same benefit of the doubt that her husband was given.
All right, Swisher, you have anything you'd like to say?
No, sir.
What was the sentence Mr. Swisher received?
I want to make clear, Ms. Hapner is correct. He got community control, but the state is not treating them differently. The court ordered community control, but we requested prison for him as well. But the state is not treating them differently.
Okay. Is Mr. Swisher serving a prison term?
No, he's in a residential treatment facility. The court granted him community control.
Yeah, he was in, residential treatment, I think, from Warren County. Yeah, according to the discovery, I remember that now, which appears to be, is she still facing charges down there?
No. No.
Okay, so they were listed at the discovery at the time. All right. How many numbers do you have, Ms. Swisher?
This will make my second one, sir. I am, so far, I'm ticket free. I'm, no write-ups. I'm in an honors program. I've been there since April. I'm on a waiting list to do hearts and a couple other programs that has to do with the drug-related things, that I need to take care of as well.
So you didn't go into treatment on your own, your husband was sent there from court in Warren County, as I understand, is that right?
Yes, sir. I was sentenced from Claremont County to prison.
Was he charged in Claremont County as well?
No, sir. Just me.
All right, so that's just you?
Yes, sir. Just.
All right, well, let me say this, if it weren't for the fact that you were in prison on a mandatory sentence from Claremont County, I would probably give a serious consideration to giving you community control. I think what tipped away the scale in favor of Mr. Swisher was the fact that he was in a community corrections facility, was doing extremely well, and the hope was that he will get over his drug problem and be able to maintain sobriety. Unfortunately, he didn't have that option since she was sentenced from Claremont County was mandatory for 3 years. She was apparently not involved in. So, given that circumstance, the court is taking that into consideration. But again, because of your mandatory sentence that you're under now, it's judged on the court that you be sentenced to the Ohio Reformatory for Women at Command at Perryville, Ohio. Did you get the jail time?
Yes, gave it to you. Only 2 days. 2.
All right. To a term of 24 months, that order to be served consecutively to the sentence that you're currently serving. And you will get the jail time credit of 2 days. Now, upon completion of that sentence, the Adult Parole Authority may, in their option, in this case, I don't know about your other case, but in this case, put you under post-judicial control for a period of up to 3 years, up to 2 years. And if they do that, you'll be supervised in the terms they set by a parole officer. If they determine that you have failed to comply, then they can turn you to prison, make you serve an additional period of up to 9 months for one violation, with a cap of half of your prison term for all violations, which would be 12 months. However, if you commit a new felony while under post-release control supervision, then in addition to whatever sentence the judge in the new case can impose upon you, that judge can also sentence you, in this case, to a period of 1 year or whatever time left on that 2 years of post-release control, whichever is greater, and if that occurs, that must be served consecutively with the sentence in the case. Now, has there been any change in your financial circumstances since you were last before the court?
No.
All right, the court then will waive your mandatory fine. And I will not oppose any jail time, any license suspension. The order paid $650 to the Allen County Task Force, and that's a sum order, which means that even if you serve your entire prison term, you still required to do it, you'll be required to make payments to the victim witness office and pay any service fees for that. Now, the order paid court costs, and if you fail to do that, then the court clerk could collect that your various fees, including legal bank accounts, wages, or other assets you may have. That doesn't collect it upon completion of the prison term, not while you're in prison. The court could order you to control, give service, give you credit for each hour you work, and rather than settle in court, each hour you work, reduce your judge by that amount until paid for. All right, is there anything further to counsel?
No, Your Honor.
Tanner?
No, Your Honor.
All right, now, Ms. Swisher, what I'm going to tell you is this. This is your promise, but after you serve your entire prison term from Claremont County, the court will consider judicial release for you. A lot of them, I'm not promising you get it. It will depend upon, what report I get from the probation department and from the institutions to how you've done there. I'm not saying that you'll get it, that you go ahead and file for it, and you have to serve your mandatory term first, and then you can file for release here. That's one of the reasons I gave you 24 months, because if I grant you judicial release, I most likely will consider drug court, and one is time to be there as an adequate sanction if you don't comply, if I should grant that. But again, it's not a promise, I'm just telling you that we consider. So I'll depend on how you do while you're there. And,
Your Honor, I don't believe she's eligible for drug court.
Why?
It's a trafficking.
Oh, that's right. I can't give you trafficking. Okay, right. I can't give you drug court, but you could give you. Yeah, that's right. Yeah, sorry about that. They changed the law on that standard. So, all right. So anyway, I'm just telling you that. Okay.
Thank you.
So you make that application. I'll give it serious consideration, and we'll see what happens. Okay.
Thank you.
All right.
This happening, you can stop over at the office to sign your form.
Okay.
All right. Daniel Wallace. Case number 21. Case number 21, CR Planting State Line versus Daniel Wallace. You're Daniel Wallace there for jail?
Yes, sir.
All right. This hearing to be conducted by Susan, attorney of Lee Armstrong. He's occurring from his office, Michigan, and prosecutor Collins. Mr. Wallace is charged with 6 counts of drug offenses, and it's a pre-trial. Let's see. I think the trial is set for October 25th. It's the final pre-trial. Now, Mr. Armstrong filed a motion to withdraw yesterday. As I understand it, Mr. Armstrong, you found out that one of the persons involved was an possible witness against him is a client of yours. You're muted there, Mr. Armstrong.
That's correct, Your Honor, and I think Ms. Collins can verify.
Okay.
That's correct.
Did you have a chance to discuss that with Mr. Wallace?
I did, Your Honor. I just filed the motion today because I was still negotiating on his behalf. The parties kind of got close to a resolution, but it broke down, so I'm asking the court to assign him other counts at this point in time.
All right. Mr. Wallace, because of him representing someone to be a witness against you, that's a conflict of interest. And so, rather than that being a potential influence or problem in the case, he would withdraw. So I'm going to grant him that leave. And I'll find another attorney for you as quickly as possible. And we'll see what happens. I'll try to get that done. I don't know if I'll get it done today, we'll get it done tomorrow. And then we'll have them get in touch with you to see, if they're going to be able to go to trial that quickly, or if they're going to need some additional time after they talk to you, or.
All right, yes, sir.
Pardon me?
Yeah, I say yes, sir.
Okay, all right. So we'll work on that as soon as possible, okay?
All right, thank you.
Thank you.
Okay.
Well, you have, green light.
Ms. Collins, you're aware of any other conflicts that might be out there?
And this is one of the cases that was a while ago before we started checking on conflicts with the CI.
I got you, all right.
I'm not sure who all has represented that CI.
Okay. Call Mrs. Hoyer and let us know what the name is, and then I'll have her research that on our records and just
Okay.
try to avoid having that repeat itself.
Likens Hapner.
Yeah, totally.
All right, are you James R. Likens?
Yes, sir.
This is case number 21 CR 125, Dave, Ohio versus James R. Likens. Mr. Likens appearing by video from by Zoom from the Justice Center. His attorney Catherine Hatter appearing from her office, as well as prosecuting attorney Collins from her office. This is the final pre-trial. Or is this the final pre-trial? First pre-trial. Let's see. Final pre-trial, trial set in 25th. All right, is discovery complete?
It is, Your Honor.
And I don't see any pre-trial motions. Ms. Hatter, you filed any pre-trial motions?
Your Honor, it's my understanding from a conversation with the prosecutor this morning that the case is going to be dismissed.
That's correct. The conversation took place about a quarter after 11 today. We haven't had time. We were in court at that time, and we haven't had time to file the motion yet, but we will, and then present it to a later grand jury.
All right. I guess that'll take care of it for the time being, Mr. Likens. So it's just a temporary dismissal. I guess I'm going to consider refiling. So yeah, let me see that. All right. Thank you. All right. Osborne.
Osborne.
All right. Are you Derek J. Osborne, appearing for jail?
Yes, sir.
This is case number 21-0138, State of Ohio versus Derek J. Osborne. Mr. Osborne is indicated appearing by Zoom from the jail. His attorney is Dennis Kirk. He is appearing by Zoom. Also appearing on behalf of the state is the prosecuting attorney, Anthony Collins. The defendant is charged with 2 counts of aggravated trafficking of methamphetamine and 2 counts of aggravated possession of methamphetamine. One was in the vicinity of school category. This is the first pre-trial, final pre-trial session the 20th, trial date is November 15th. And I see there's been some discovery provided in the defendant, and have you provided your yes, Mr. Kirk?
I have not yet, Your Honor.
Your discovery we do by final pre-trial, and are you intending to file any pre-trial motions or?
Not at this time.
Has it been written provided?
Yes, Your Honor. On September 21st, we provided a plea offer to Mr. Kirk.
Is your client aware of that yet?
Yeah, there was a plea offer provided. I have relayed that to him.
All right, any other matters being come before the court?
Not from the defense at this time.
All right, then we'll see you on your next pre-trial. Thank you.
Thank you.
Lena Henry, I believe. Wait, she in jail?
She's
She's online, Your Honor, but she's not in jail.
Okay.
She's on the Zoom call.
We have two more in jail.
All right, we need to finish the draft. So Woodruff is the next one.
Actually, 3 more, yeah. Woodruff.
All right, are you Robert Woodruff?
Yes.
Okay, this is case number 21 CR 146, Dave, Ohio versus Robert L. Woodruff. Mr. Woodruff is appearing by Zoom from jail. His attorney and William Armstrong, who's also appearing by Zoom from his office. Appearing on behalf of the state is the prosecuting attorney at Collins. Defendant's charged with burglary and theft along with a co-defendant, Ms. Henry. This is, I believe, a first pre-trial, and I believe, let's see here. The same place. November 15th is the trial date, October 20th is the final pre-trial. All right, now do you see that there's a discovery has been provided? If you provide your discovery yet, Mr. Armstrong?
I filed it, early this morning, Your Honor.
All right. And you anticipate any pre-trial motions?
None at this time.
Has there been a written plea offer?
Yes, Your Honor.
Looks like it was dated yesterday, Your Honor. I picked it up today. My client is not aware of it. I went out to speak with him at the jail about discovery and whatnot. I guess he'd actually made bond for a while, but now he's back in collection. So I have not had a chance to communicate with him.
Okay. All righty. My understanding he was taken in custody by the probation department on the municipal court of order on October 4th. You are a model in this case, Mr. Woodruff. You should be released from the municipal court charge before the probation immediately because I've got a notice here you didn't report when you were released on the 1st of October.
Yes. By the time I got everything was closed.
Well, then you go the next day, which you've been nothing, unless you got arrested before.
I had court for municipal court Monday. I was already sentenced to 10 days back in July.
Okay. All right. Well, then when you get out of jail, report. Okay. All right. Anything further, counsel?
No, Your Honor.
All right. Thank you. All right. The final one in jail.
We have two more.
Two more.
Christopher Hertzler and Thomas Shoemaker, and then we have a 3:30 jail, 3 o'clock jail.
Christopher Hertzler, please.
Yes. Hertzler?
All right, this is case number 21 CR 165, State of Ohio versus Christopher Hertzler. You're Christopher Hertzler? All right, this hearing being conducted by Zoom due to the COVID-19. There's no counsel of record yet in your case, Mr. Hertzler. I noted that at the time of the range you were going to hire your own attorney. Have you employed counsel yet?
No, I had asked for a public defender and you had issued me, Catherine Hefner. But I haven't spoken to her.
Your Honor, I've not been appointed.
I don't see an entry here where I appointed you.
Yeah, I've not received any appointments.
I think it's online. We knew that as well.
No, I checked yesterday afternoon, about 4 o'clock, because I received a plea offer, but I have not been appointed.
All right, you're appointed. Okay, that fixes things. So, we'll be in touch with you, Mr. Hertzler. We'll appoint this after. I don't know. I don't see anything in here from the file. I don't recall a conversation, but we'll go ahead and do that.
That's where I got that name from. You had told me.
Maybe I told you that in a mail or two. I don't remember. My memory's not what it used to be. So
I was trying to get like a bond reduction or.
Well, you can talk to her about that, and we'll discuss that then.
Your Honor, it was at the bond review, you put it in the entry for the bail.
Oh, is that what I did?
Yeah, that's what you did. She was appointed on September 23rd.
Well,
yeah, I've not received any appointment.
Yeah, it's not in the file. The last thing says.
The bail review entry?
Yeah. Oh, wait a minute, let me look here.
September 23rd.
Oh, yeah, it is in there. Okay, there it is. All right.
Well, regardless, it wasn't given to me.
Okay, no problem. Okay. So, but you're his attorney. All right.
Okay.
Okay, thank you. Thomas Shoemaker.
Thomas Shoemaker. Then we have one more Zoom after that.
At what time, 3:30?
We have one. It's still more 1 o'clock. It was a non-jail. That Lena Henry.
Yeah, she's on the line, she's not jail.
Right. She's
We don't have anyone in jail.
3 o'clock, right?
All right. Are you, Thomas, Shoemaker, appearing from jail?
Yes, Your Honor.
All right, we have, 2 cases here, involving the same defendant, Thomas Shoemaker. First of all, we have case number 20 CR 147, and the other one is 21 CR 166. This hearing is being conducted by Zoom due to the COVID-19 issues. The defendant's attorney is Jake Weiger. He is present by Zoom. Present on behalf of the state is prosecuting attorney Collins. The defendant is charged in 20 CR 147 with grand theft of a motor vehicle. And that case is set for November 15. And then failure to appear in 21 CR 166. And I believe this is set at the same time. Now, I've been presented with pleas of guilty in this case, in both of these cases, Mr. Shoemaker. These are 3-page forms. Prosecutor's office prepares from their computer format. They put in the information that's relevant to your case and cases. Print it out. And I'll show you, first of all, 20 CR 147, which is the grand theft. You recognize that form there?
Yes, Your Honor.
And 21 CR 166. Hold that up to the camera, you recognize that.
Yes, Your Honor.
All right, now on page 3, on each of these forms, there's a sentence that reads, I entered this plea voluntarily. And below that, there are signature lines, and this is 20 CR 147, there's a signature line, signature defendant. I can't read that signature, but is that your signature that I'm holding up there to the camera?
Yes, Your Honor.
And then in the other case, 166, is that your signature next to the index finger? All right, and when did you sign these 2 agreements, Mr. Shoemaker?
Yesterday morning.
And is that at the jail there?
Yes, sir.
Is your attorney present to go over this with you and explain it to you?
Yes, Your Honor.
And when you signed it, did you understand that it's agreement to plead guilty, which means there won't be a trial in either case? The next step would be a sentencing hearing?
Yes, Your Honor.
Do you have enough time to fully consider this matter before making this decision?
Yes, Your Honor.
Do you feel you've been rushed or pressured in any way?
No, Your Honor.
Are you entering the agreement to plead guilty in both of these cases voluntarily?
Yes, Your Honor.
Now, the agreement on page 1 and 20 CR 147 says you're going to withdraw your not guilty plea, plead guilty to grand theft of a motor vehicle under 2913.02A1, 4th-degree felony. Further states you understand the maximum penalty for that is 18 months in prison, and the prison term imposed minimum could be 6 months. There's a fine available up to $5,000. The mandatory fine on grand theft of a motor vehicle? There's not, is there? That's printed, that's what's printed there. Alright, that's not, there is no mandatory fine. Alright. Then on the other charge, 166 says you're going to withdraw your plea of not guilty, plead guilty to failure to appear under 2937.99 revised code, a 4th-degree felony. And again, the maximum prison term is the same, 18 months, a minimum of 6 months, fine of up to $5,000. You understand that? Mr. Shoemaker, if you are convicted of both offenses and sentenced to prison, those sentences can be ordered to be served consecutively, one after the other. And so that means that 18 months in each case would be a total possible of 36 months. You understand that?
Yes, Your Honor.
Are you facing any felony charges anywhere else? Are you on probation, community control, parole, post-release control for a felony in any jurisdiction?
No, Your Honor.
Right now, under the law, if you're convicted of these offenses and sentenced to prison, once you complete the prison term, it is possible that the adult parole authority will put you under post-release control for a period of up to 2 years. But it's up to them, not the court, and if they do, you'll be supervised on the terms they state, and if they find that you have failed to comply, they can return you to prison for an additional period, up to 9 months for one violation, up to a maximum of half of the prison term for all violations. However, if you're committed a felony, then in addition, whatever sentence the judge in a new felony case proposed upon the judge could also sentence you in this case to an additional period of 1 year, or whatever times up on period supposed to control whichever is greater. If that occurs, then it'll be served secondly the sentence in this case. You understand that?
Yes, sir.
Now, under the law, I'm not required to sentence people convicted of this offense or offenses to prison. I can impose community control instead, which means that if you don't go to prison, that you are put under up to 5 years of supervision by the probation department under terms set by the court. And if during that period of time they felt you were not compliant, they would file a written notice at the court, serve a copy on you, you'd be entitled to have a hearing, be represented by an attorney. The outcome of that hearing was that you had failed to comply. Then at that time, the court would revoke community control and then sentence you to prison in each case at 18 months, total 36 months, and fine you $10,000. So, you understand that?
Yes, sir.
Right now, the charge in the first case, 20 CR 147, alleges that on or about February 20, 2020, in Highland County, Ohio, you did with purpose to deprive Western voters of their property, knowingly obtain or exert control over said property with a 1998 Chevrolet Silverado truck, property being a motor vehicle defined in ORC 4501.01, 1000% of Western voters, the owner of the person authorized to give consent. Then that's the charge of grand theft of motor vehicle for 3 felony. And then 21 CR 166 alleges that on or about August 18 of this year in this county, we did recklessly fail to appear as required in Highland County Common Police Court case number 20 CR 147 after having been released pursuant to RC 2937.29 and released in connection with the charge of commission of felony in violation of section 2937.99. So that's the charge of failure to appear, also for 3 felony. Mr. Shoemaker, do you understand what it is you're charged with in each of those cases, what the state said you did, when, where, how, the rest did it?
Yes, sir.
You understand the possible penalties for both offenses?
Yes, sir.
Have you discussed the nature of each of these charges, the evidence in the case for each, possible legal issues in each case, possible offense you try to raise in each case, possible outcomes of the trial in each case with your attorney?
Yes, sir.
All right. And are you satisfied with his advice and comments in this matter?
Yes, sir.
I realize I'd like to say at the beginning, but Mr. Wagner, you and your client both stipulated this appearance to be remotely rather than in person.
Yeah, we spoke about it yesterday, Judge.
All right, you're all right with that, Mr. Shoemaker? You're all right with appearing by video, Zoom, rather than coming up here?
Yes, sir.
Okay. And if you have any questions that you need to ask Mr. Wagner or anything you'd like to talk with him about at any point, you just tell me and I can stop in and put you into a breakout room so the two of you can talk off screen, just to each other, just the two of you on that screen, no one will be able to hear you or see. Okay?
Yes, sir.
All right. Sorry to interrupt that. It occurred to me, I forgot that. All right. Now, are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs?
Yes, Your Honor.
All right, what kind of drugs are you taking?
The Tylenol 50 milligram blood pressure.
Okay, just heart issue, all right. It doesn't interfere with your ability to understand what's going on or comprehend things.
No, Your Honor.
Has anyone threatened you to get you plead guilty?
No, Your Honor.
Now, on page 2 of each of these agreements, there are some lines that are printed in bold and underlined. In the first page, the 20 CR 147, there's 3 lines that read as follows. Defendant shall enter plea guilty to the indictment. State defense shall recommend 9 months incarceration, second sentence of case number 21 CR 166. Defendant shall pay full restitution. In the 21 CR 166, it says defendant shall enter plea guilty to the indictment. State defense shall recommend 6 months incarceration, and second sentence of case number 20 CR 147. So that'd be a total of 15 months. Is that your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that in case you plead guilty here today?
Thank you, Your Honor.
Under the law, the matter of sentencing is reserved to the judge, not the party. So even though there's agreement that you plead guilty and get a particular sentence, I'm not required to follow that. So once I hear all the information that's submitted during the sentencing, if I decide that's not the correct sentence, I could impose any sentence up to the 36 months max. You understand that?
Yes, Your Honor.
And is there an agreed amount of restitution, Ms. Collins?
No, Your Honor, we have been in contact with Westview Motors on a number of occasions. They approved the plea offer even, but they've not given us a restitution amount. Even after being advised we had to have it by today.
All right. Now, you hold any license or certificate from the state of Ohio, the government of the state of Ohio, for any occupation or profession?
Are you talking about health or just, I have a HVAC license.
Yeah, that's a trade certificate. You know, things like an engineer, nurse, nursing assistant, barber, things like that. Okay. Now, under the law, you have rights you need to understand before I can accept guilty. First, you have right to counsel, and Mr. Weiser's appointed to represent you, not simply work the case out, but provide any defense that might be available to you under the law that you wish to provide. So, if you decide that you do not want to plead guilty, that you want to defend this case, then he will still continue to represent you, including a trial, if that's what you want. You understand that?
Yes, Your Honor.
All right, now, under the Constitution, you have a right to a jury trial in these matters, in which a jury of 12 persons would be selected from a group of citizens from this county, summoned for jury duty under a trial day. After they are selected, the evidence will be presented, and then the judge will instruct them on the law. And they will decide by unanimous verdict whether or not to say truth or guilt, that proof beyond that. Now, if you decided you didn't want to have a jury trial, but you did want to plead guilty, then, wait a minute, I will let it there. Let me back up, start over. Mr. Armstrong was appointed to represent you in this matter, and I wasn't sent to work the case out, but to provide any defense that might be available to you under the law we wish to provide. So if you decide you don't want to plead guilty, you'll still represent you defend you. You understand that?
Yes, Your Honor.
Okay. I may be repeating myself, but I was trying to do too many things at once here, trying to look ahead and see what I was going to do next. And so whenever I do that, I get myself confused. So the next right you have is that you have a right to a jury trial. And in that case, 12 people will be selected from a group of citizens that were summoned for jury duty under the trial date. After they were selected, the evidence would be presented, the judge instructed on the law, and that jury then would have to decide on a unanimous verdict, 12 have to agree whether or not to say truth or guilt or prove beyond a doubt on every essential element of each offense. Now, if you didn't want to have jury trials, you didn't want to plead guilty, you can waive in writing, that means give up, right, have a jury trial. In that case, you have a court or bench trial, meaning the judge would be the one to hear the evidence of the jury. The judge would apply the law, the judge would be the one to decide whether or not to say truth or guilt or prove beyond a doubt. You understand that?
Yes, Your Honor.
The Constitution, in each of these cases, you have a right to confront witnesses against you and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come to court, testify in open court in front of you, your attorney, and anyone else may be present. After the prosecution then asks you questions, your attorney asks questions, that's called cross-examination, the purpose of which is to bring out evidence that helps your side. You understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So, if you have witnesses you're not certain are going to come in voluntarily, you request for issue court orders called subpoena, and that forces those people to come to court to be able to testify if they want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes, Your Honor.
Under the Constitution, you have a privilege against self-incrimination in each case. You cannot be forced to give evidence in either case against your will at any time. In fact, no one can make a testify, the prosecutor can, the judge can, and no one's allowed to talk about it or mention it during the hearings on the cases, except in one situation. If you decide to have a trial in front of a jury on either of both cases, and you do not testify in those cases, then the judge will instruct the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Under the Constitution, you're presumed innocent of each of these charges until proven guilty by the state of Ohio. of every essential element of the offense charge. What that means is that the burden of proof isn't on you to try to show you're not guilty. The burden is on the state to prove that you are. In fact, you're not even required to present any evidence at trial. You can, but you're not required to. Whether you do or not, burden of proof will remain on the state of Ohio to prove your guilt on every essential element of each offense by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
Right, and Mr. Shoemaker originally entered a plea of not guilty in each of these cases. That plea denied the allegations in the indictment, denied he committed any crime, and exercised or invoked all the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty plea. Guilty plea admits the allegations, admits that there are crimes that you committed that crime. And that plea waives, gives up all of the rights that I've just described for you in each case, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. Without exception, your plea of guilty waives, gives up your right to have a jury or court trial. Waives, gives up the right to confront witnesses against you and a cross-examine through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. Waives, gives up your privilege of self-incrimination because if you say you're guilty, that's what you find you guilty. And waives, gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced in each case by the court. And finally, in each case, it waives, gives up any right to file an appeal you think you could have in either case up until this point. Now, by sentencing the maximum sentence, under certain circumstances, you file an appeal that will have to be filed within 30 days of your sentencing after being filed. You understand all of that?
Yes, Your Honor.
Are you a U.S. citizen, Mr. Shoemaker?
Yes, Your Honor.
Right, do you have any questions about the charge in either case or the possible settlement?
No, Your Honor.
You understand?
Yes, Your Honor.
Any questions about the plea agreement in either case?
No, Your Honor.
You understand it?
Yes, Your Honor.
Again, you understand the court's not bound by the sentencing recommendation.
Yes, Your Honor.
Any questions about the constitutional rights of this claim?
No, Your Honor.
You understand them?
Yes, Your Honor.
Have any questions about the plea of guilty, what it means, what will happen in that plea here today?
No, Your Honor.
You understand?
Yes, Your Honor.
Anything you need to speak to your attorney about before we go any further?
No, Your Honor.
You have any questions about anything I've explained to you here today?
No, Your Honor.
This is your decision to withdraw your not guilty plea guilty to these two charges pursuant to the terms of the plea agreement in each case.
Yes, Your Honor.
Right, then as to the charge in case number 20 CR 147, alleges that on or about February 20, 2020, in Huntington County, Ohio, you did with the purpose to deprive Westview Motors of their property, going to maintain and exert control over said property to wit a 1998 Chevrolet Silverado truck, property being a motor vehicle, is defined in ORC section 4501.01, without the consent of Westview Moters, the owner person authorized to give consent, violation of section 2913.02A1, the Ohio Revised Code, a fourth degree felony, carrying possible prison term between 6 and 18 months and fine of $5,000 as received.
Guilty.
As to the charge of 21 CR 166, it alleges on or about August 18, 2021 in this county, you did knowingly, recklessly fail to appear as required in Huntington County Common Police Court case number 20 CR 147. After having been released pursuant to RC 2937.29, released in connection with the charge of commission of felony, violation section 2937.99 advised code, failure to appear fourth degree felony, carrying the same heavily of 6 to 18 months in prison, fine of $5,000 and plea.
Guilty.
All right, the court finds that on this day, in open court, the defendant provides all his constitutional rights, made knowing, voluntary waiver of saying, pursuant to Rule 11, please the second court file, and it is found guilty of these offenses. I'm not sure if I asked you, but you are a U.S. citizen, Mr. Shoemaker.
Yes, Your Honor.
All right. Inasmuch as this is a recommended sentence, and I have looked quickly at the discovery to see Mr. Shoemaker has previous conviction, so the court is going to go ahead and proceed with sentencing for Mr. Collins on behalf of the state.
Your Honor, we would ask the court to follow the joint recommendation outlined in the plea agreement, noting the defendant's prior criminal history, which is primarily property crimes, and quite a collection of them. Additionally, he obviously committed the failure to appear while under pretrial supervision under bond for the other case. So based on that, we would ask the court to follow the joint recommendation and impose consecutive sentences. Thank you, Your Honor.
Right?
We would ask the court to file the recommendation, speaking with Mr. Shoemaker. This is again another deal where I know the court's not happy on the failure to appear. Mr. Shoemaker, following being returned to be discussing with him, want to get this resolved as fast as possible. He's not here playing games, Your Honor. So we simply ask the court to file the recommendation.
All right, Mr. Shoemaker, do you have anything you'd like to say?
No, Your Honor.
See, this situation where I granted you a medical furlough, then you didn't return, right?
Yes, Your Honor.
All right. And I see you have quite a few prior convictions. How many different times have you served time, Mr. Shoemaker?
I've been in the Ohio Department of Corrections one time.
How many?
One time in the Ohio Department of Corrections.
How many times in Indiana?
One time.
Okay.
The Indiana and Ohio, there's like one incident, and I know they're separate counties, but I got sentenced and went to prison and did my time, and then Ohio. They was both done at the same time, Ohio and Indiana. Whenever I did my Indiana time, then I come over and did my Ohio time.
So you had two charges in 2003, one out of Hancock, one out of Hendricks County, Indiana, and then another one in Johnson County in 2005.
Shelby County too.
And who?
Shelby.
Oh, Shelby
County. Johnson, Shelby, and Hancock County.
All right.
Like I said, it was
You had a burglary charge in 2010 out of Pike County, which if you've been in prison for 12 years in 2003, you've never had the chance to do that, so.
Your Honor.
You got out of prison. Don't interrupt me, Mr. Shoemaker. And then 2014, robbery out of Pike County. 6 years incarceration. Apparently you didn't spend that long there either because you got domestic violence in 2017 and unauthorized use of property in 2019. So it doesn't appear you've ever had to serve any term completely. Is that an accurate statement?
No, Your Honor. I committed the crimes in Pike County and then in Indiana. All right, I got sentenced to Indiana first, and then 7 years into my sentence in Indiana, I filed for Ohio to come and get me. That's where I got sentenced in 2010. I got out in 2012, went right back. That's my second time in a joint to Ohio for 3.5 years. Then I got out in 2015 and been out all the way until now.
But according to the record, you were supposed to do 6 years for robbery out of Pike County.
I've never had a robbery. It's all been burglaries.
All right, it says robbery in that 3 and theft. Okay, so.
I got sentenced to 30 months on that 15 and 15.
Oh, yeah, sentence.
I got sentenced to 15 years or 15 months on the F3, 15 months on the F3 grand theft of firearm, rank second, 30 months.
Okay.
That's not even a possible sentence.
That's what they sentenced me to. I mean, if you look at my Department of Corrections, that's the top.
15 months isn't a possible sentence.
Well, I mean, if you get contact Pike County, they'll tell you that's what they sentenced me to.
All right. Well, Mr. Shoemaker, one thing I'll say about you, this is my observation. I've been doing this for 45 years, going on 46, and I look at this record, it looks to me like you're just a professional. That's your occupation. You're breaking into places, burglaries. You've got a heck of a lot of breaks. I mean, you've got 12 years, for goodness sake, in one charge, but you didn't serve it. I should have been locked up a lot longer for some of your previous crime. But you've always got breaks. And then here, I let you out of jail because you had a supposed medical problem. And unfortunately, there's been a rash of those things. And I'm getting to the point where I can tell the sheriff that somebody says they've got a problem, put a Band-Aid on it and send it back to the cell. Because, people like you just use that as an excuse to get out. Now, we had another guy who the sheriff hardly had left the hospital when he ran, because he's supposed to be transferred, but he's supposedly injured his back. So I'm just getting real tired of that kind of crap. And looking at your situation, it appears to me that no person's home or property is safe if you're a free man. So it is a judgment of the court, case number 28 CR 147, that you be sentenced to a term of 12 months at the correctional section of Lorraine, Ohio. And in case number 21 CR 166, here, it's ordered to be sentenced to a term of 12 months. The sentences are ordered consecutively to each other for a total of 24 months. The court imposes consecutive sentences in part that it wasn't agreement, although not as the time, of course, the second. He committed the second offense while under bond and awaiting trial in the first case. Also, if there was ever anyone's record who justifies that it's necessary to protect the public from future crime, it is this case. Also, these sentences are not disproportionate. They're middle of the road sentences, but one sentence was not accurate, reflecting the seriousness of this defendant's harm caused to these different cases. Now, according to the sheriff, we have 4 days credit on case number 20 CR 147 and 21 on case number 21 CR 166 for a total of 61 days. Now, upon completion of these prison terms, Mr. Shoemaker, the adult parole authority may, at their option, choose to put you under post-release control for a period of up to 2 years. They don't have to, but it's up to them to do. You will be supervised by a parole officer in the terms they set. If they find that you have failed to comply, they can return you to prison for up to 9 months for any one violation, up to a maximum of half of your prison term of 12 months for all violations. But if you commit a new felony, then in addition, whatever sentence the judge in the new case can impose upon you, that judge can also sentence you in this case to an additional period of 1 year, whatever time left on that, for 2 years post-release control, whichever is greater. If that occurs, it has to be served consecutively the sentence in the new case. You also order paid court costs, which has to grant execution order. If they don't do that, court will have you do community service after you get out of prison, not while you're in prison, and you can give credit for each hour work, and hourly rate set by the court, each hour work, reduce your judgment by that amount until paid in full. All right, is there anything further, counsel?
Yes.
Okay, remand in custody.
You want to do the last? You want to do the last jail one?
Yeah.
Okay. Fisher.
Fisher.
Last one in the stack.
All right, can you bring me Mr. Fisher?
Yeah.
That's the last one in jail.
In jail, and then we have one more Zoom.
All right. And then I have one on Zoom with Ms. Hampton.
Yes.
Okay, well, we're waiting on that. Let's go ahead and do this. Ms. Henny, would you go ahead and unmute yourself? You've been here for the entire time, so go ahead and let you go. So, wait for this case number.
1 minute, Your Honor. Henry?
Henry. Oh, Henry, I'm sorry.
Okay, on the record.
Case number 210145, State of Ohio versus Leanne Henry. You're Leanne Henry there from the car?
Yes, sir.
All right.
Yes, sir.
All right. Henry is represented by Pastor Kapner, who's appearing by Zoom in her office, and Ms. Collins is appearing on behalf of the state in her office. The defendant is charged with burglary, theft. This is a first pretrial, I believe, and the final pretrial is the 20th, and we have a trial of November 15th. See, the state has provided a bill of particulars and discovery is, have you done your, provided yours yet, Ms. Hacker?
No, not yet.
All right, here's the legal final pretrial. Do you anticipate any pretrial motions?
Not at this time, but I'll reserve that.
Are there any do you do by the final pretrial as well? Do you have, or has been a plea offer received?
We provided a plea offer.
Yeah, that's what I was just thinking about. I think I've seen it, but I do not believe that I've given it to my client yet.
Okay.
No, sir, I haven't received it.
Okay. All right, any other matters then to discuss?
No, Your Honor.
All right, Ms. Henry, you were released from jail on the 1st of October, other than Friday. You were supposed to report to the probation department. I have a email here that, fax that says, as of yesterday, at 3:51, you did not report. Did you report today?
I am on my way, sir. I stopped for court so I wouldn't lose service. I am actually staying in Urbana.
All right.
I'm staying in Urbana with the people that bailed me out. So we
where are you?
on our way. Oh, I am in Jeffersonville, the Flying J. I'm just waiting on my court to be over, and then we're hitting the road again. I'm going straight to the probation department.
All right. How late are you there, Mr. Sheila?
We walk out at 4.
All right. Tell you what, better come back tomorrow, because they're not going to be there. So.
Okay.
But you need to report, because that's an order to report. You got to do it every week for 4 weeks.
Yes, sir.
So.
I did attempt to Monday as well, but I got there late. Then I was trying to gather my clothes and stuff because I had none left.
I believe the probation department was closed on Friday and Monday.
We're closed Friday, we were open Monday, and all this week.
Okay. All right. Okay, so just make sure you report. All right, thank you.
Thank you.
Your next hearing will be by Zoom as well. Okay, Joshua Fisher. Oh, they don't have him up there yet. You can go ahead and sign off, Ms. Henry. What's going on out there?
They shut the door, there's gotta be something afoot.
Maybe.
Somebody standing outside the door.
Nick's just standing out there.
Yeah, there he comes.
Here he comes.
On the record, Fisher.
Case number 18 CR 76, never mind. State of Ohio versus Joshua S. Fisher. This hearing being conducted by Zoom, and are you Joshua Fisher appearing from jail?
Yes, sir.
All right. Mr. Fisher's attorney is who's also appearing by Zoom in his office, and appearing from the prosecutor's office is Prosecutor Collins. This is a hearing on a probation violation, and Mr. Armstrong, did you discuss this with your client and agree to have this hearing conducted remotely rather than in person?
Yes, Your Honor, we spoke yesterday, and I told him we would be by Zoom. He's agreeable with that.
All right. All right. The defendant was convicted in this court of on April the 29th of 2020 June 15th of 2018 burglary, a second-degree felony, and was sentenced to a term of 3 years. On April the 29th of 2020, the defendant was granted judicial release and control, and on September the 20th of 2021, the court received a notification of alleged violations from the probation department and notified Mr. Fisher of those allegations and appointed Mr. Armstrong to represent the defendant. Now, Armstrong, you had an opportunity to discuss this with your client.
I have, Your Honor. At this time, he's prepared to admit the violation, rule number 18, not having made any restitution payments since April of this year, but no further admissions.
All right. And then state prepared to proceed with hearing?
Yes.
All right. Call your first witness.
State call Sandy Kelly.
All right, Ms. Kelly, would you raise your right hand and be sworn, please? You need to tilt your screen down with your audience part of your face, sir. All right. Do you solemnly swear that the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and full record report that, so Ms. Kelly, since she's the commission officer for this court. Alright, you may inquire.
Ms. Kelly, are you familiar with Josh Fisher?
Yes, I am.
And how are you familiar with him?
He was placed on my caseload when I took over, as part of the community control supervision. I last met with him in May 5th of 2021.
On May 5th of 2021, prior to that, was he complying with the rules and regulations of probation as filed with the court?
According to the other officers' records, it was kind of sporadic reporting. I had only met with him that time, and then that was the only time that I had seen him.
We would ask the court to take judicial notice of the rules and regs that were filed in this case for community control.
Yeah, court recognizes, makes this.
And on the 5th of August, 2021, did you advise Mr. Fisher to return for a follow-up report date?
It was May 5th.
I'm sorry, May 5th.
That's right, and yes, he was given another report date.
And what was that report, what day was that report date for?
I don't have that on me. Usually we have everyone report once a month. So it would have been for June.
Was he scheduled to report monthly at that time?
Yes.
Okay, so he was told to come back in June?
Yes.
And did he return in June?
No.
Did he make any contact with the probation office to explain why he did not report?
No, he did not.
Did he report in July?
No.
In August, did you send a letter to the defendant's address?
Yes, I sent a letter to the Marion address that he had listed as his last residence. It came back returned to sender.
And had the defendant provided the probation office with an updated address?
No, he had not.
Is that one of the conditions that he keep the probation office notified of his current address?
Yes, it is.
As to, during his time on community control, was it noted that he needed to engage in some sort of substance abuse treatment?
Yes.
And was he referred to do that?
He was, however, no documentation was provided to me by him stating that he had completed any kind of treatment and or aftercare.
So did you recommend it, or did you order that he enter some sort of treatment?
I advised him whatever certificates he had that he had completed to bring them to me so we could go over them and we could discuss what he needed to complete after, if anything.
And if he needed to do that after you met with him on May the 5th?
Yes.
But you haven't seen him since May the 5th, correct?
Correct.
Has he provided you with any sort of explanation as to why he has not been reporting?
No, he has not.
And how was Mr. Fisher located?
He was arrested on September the 17th. That was on a Friday night, I believe. And then he was served his violations in Highland County on September the 20th.
So this wasn't an instance where he turned himself in?
No, it was not.
At this time, are you aware of other charges the defendant has pending?
Yes. He also has a felony probation violation out of Warren County for failed to appear. He has not been reporting or compliant with their agency as well. As of yesterday, I located new charges that the defendant was either convicted of or charged with. One was in Marion County on September 13th of 2021. It was an M1 theft. On February 23rd, 2021 in Delaware County, he was charged with criminal damaging and endangering. And then in Claremont County, there is also January 8th of 2021, he was cited for DUS, which he did not advise us of.
And is that an additional requirement with probation?
Yes, any kind of law enforcement contact is to be notified by our office by the next business day.
I have no further questions.
Ross?
Ms. Kelly, you're stating that he was ordered to appear in June. You can't give us a date when he was ordered to appear, correct?
And no, at this time I cannot. I would have to log out of Zoom and then pull up the where we logged all of our information and our programming.
And isn't it true that Mr. Balzer was a previous probation officer, is that correct?
It was, yes.
And while you have not seen him since May 5th, are you stating under oath today that he has made absolutely no contact with your office since May 5th?
He has had no contact with me.
That wasn't my question, it was with your office.
That I don't know.
Okay, now, do you have, if somebody calls in after hours, are they able to leave a message?
Yes, they are.
Is there a law of calls that come in with attached phone numbers?
I know, it just goes, each of us have a direct line. When you call the office, you punch in whatever extension to whatever officer you want. We can leave a message for that officer.
Is there like a long history of phone calls that come in and the numbers, if you're aware of that?
Just if an officer logs it in the system, that's it.
Okay, did you check that log to see if you received any phone calls from the last phone number that you had from him?
Yes, I did.
You didn't find any?
The last phone number I contacted, that I had for him, I contacted, a female answered the phone, said she had never heard of him.
You know, if Mr. Balzer had any contact with him after May 5 of 2021 by phone?
I'm not aware if he did or not. I would have to double check.
Okay, so if he did, you're not aware of it. If he didn't, you're not aware of it, correct?
Correct, yes.
Now, do you have the address that you sent the letter to that came back?
I did, yes. I actually have the letter here.
And that was the address you're going to share with us. That's the last known address that you had?
Yes, it's 3068 Marion Waldo Road, Marion, Ohio.
Okay. Now, are you aware of whether or not he did any, I believe he successfully completed the STAR program, is that correct?
I don't know, Your Honor. I don't know because I don't have any kind of certificates or information of what he's completed and what he hasn't completed.
Did you yourself ever refer him to any specific place for an assessment of any kind?
No, I did not.
You know if Mr. Balzer did?
I do not know.
You know if he had any other officers besides Mr. Balzer?
No, he did not.
That's all, Your Honor.
Redirect.
Sorry, what?
Redirect.
None, Your Honor.
Alright. Any further witness?
Not from the state.
Any witness in this regard?
Mr. Fisher, Your Honor.
Alright, Mr. Fisher, raise your right hand and sworn. You solemnly swear about the testimony about to give will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
Alright. Any part of the trial?
Josh, just state your name real quick if you would.
Joshua Stephen Fisher.
And you had a chance to hear the testimony of Ms. Kelly, correct?
Yes, sir.
And you do, I think you do agree the last time you were actually on site at the probation department was May 5th, correct?
Yes, sir.
But now, if you would explain to the court if you have had any contact or attempted contact with that office since May 5.
Yes, sir.
That works.
In June of this year, I tried to contact the probation department, left a couple messages with Sandra Kelly with no reply, so I contacted Drew Balzer, spoke with him on the phone. I had started a job at a company called Silverline Windows in Marion. They had a thing where if you didn't miss work for 30 days, you got a $1,000 sign-on bonus. So I called Drew and I explained that to him. And at the time, he said that he would take care of it, that it was okay. As far as the sporadic, I never missed a report date before May. And
just a second, did you get your on myself here? Did you speak with Mr. Balzer on any other occasions?
I didn't speak with him on any other occasions, but the beginning of August, I believe it was either the 2nd or 3rd, I contacted Mr. Balzer, or I called and left messages with Mr. Balzer giving my new address because I had obtained a new house. The 3068 Marion Waldo Road, the reason that was returned is because there is a lot number, it's lot 104, it's a trailer park. I put that lot number into the system every time I reported to probation. Drew knew that I lived there. I resided there with my fiance and her mother. And the only reason I can think that would have been returned is because the lot number was not put onto the address.
All right, now, you knew Ms. Kelly was your officer at that time, right?
Yes, sir. And I had attempted to call the probation department on numerous occasions. My wife has attempted to call the probation department on numerous occasions, and it's very hard to get a hold of someone there. And like I said, I've been used to speaking with Drew, and I understand that may have been on my part.
I'm asking some questions here. Obviously, your wife's not the one on probation, right?
Yes, sir.
Was she calling on your behalf?
Yes, sir.
Now, you gave me some documents, and Ms. Collins, I apologize, you have not seen these documents. Judge, do you have them? I filed them with the clerk.
I wonder where they came from. I see something here from My Place Hotels. I see a rental agreement. I see something from Access Ohio. Is that what you're referring to?
It is, Your Honor.
All right, so those are exhibits you wish to ask about?
Yes, Mr. Fisher.
Which one are you going to list identify as A, B, and C?
Access Ohio, Your Honor, would be our number A.
Exhibit A, all right.
And Josh, you provided me with that document, correct?
Yes, sir.
You have it in front of you right now?
I do not, but I know what the document stated.
We expect that you got back to jail, though, right? You don't have it in front of you right now.
Yes, sir.
Okay. And as I'm reading this, that you've been a client of Access Ohio since January of 2021, correct?
Yes, sir.
And then it said that here on February 23rd, you had an initial psychiatric evaluation, and that you were consistent with appointments for about 4 months, two months. Is that correct?
Yes, sir. I had an AOD assessment in January because Drew advised me that I just needed to get an assessment done, and that if they felt like I needed treatment to go along with that, but if not, it was okay, that the judge just wanted me to have an assessment done. I immediately made the appointment in the beginning of January for Access Ohio. I had my AOD assessment done in the beginning of January. They felt because I completed the STAR program and I also completed a Christian-based drug program while incarcerated in prison, that I didn't need to be placed in any type of AOD treatment, in-house or outpatient.
Did Ms. Kelly or Mr. Balls or either one refer you to a specific program?
No, sir. He told me that I just needed to get an assessment done and where at didn't matter.
Now, I also have a letter from a place called My Place Hotel. What was that about?
That was where I'm currently working.
Yes, sir. I'm sorry.
That's where I'm currently working. I'm a housekeeper / maintenance person there. I've been there since leaving Silverline. I left Silverline towards the end of June due to having COVID. I lost my job, and I was able to obtain the job at My Place Hotel shortly after that.
So is this job still available if the court were to continue your probation?
Yes, sir. Yes, sir.
And the last one, Judge, would call it as C. It's a rental agreement, Josh, and this is, I believe, would be your current address now. Is that correct?
Yes, sir.
Give that address to the court.
I apologize.
Give that address. What's the address of the new place?
239 Pearl Street in Marion, Ohio.
Okay.
43302. It's a house that my fiance and I was able to obtain.
Okay. That's all.
Cross?
Yeah. Mr. Fisher, you stated that the reason that you weren't reporting in June was because you had a job where you knew you had to report back in June, that you called and left a message that you got a job where you could work 30 days in a row and get a $1,000 sign-on bonus, and that's why you didn't report. I
didn't call and leave a message. I called and spoke with Drew Balls.
Okay, so I'm right though. That was the reason that you quit reporting.
In June, that's the reason I didn't report. In July.
And then you lost that job at the end of June, correct?
Now, can you answer the question before she jumps in with another one?
Yeah, you're the question. The question is, did you lose that job?
I lost the job at Silverline due to having COVID. I was out of work for 18 days, and then once I was able to go back to work, it was about, I think it was the 8th or 9th of July, I was able to obtain the job at My Place Hotel.
So the answer is yes, you lost the job where you were getting $1,000 for 30 days and not missing work.
Yes, ma'am.
So, but you didn't go back and report, even though that was the reason you weren't reporting.
Because Drew advised me that it was okay not to report in the month of June.
What about July?
That, I agree. I fully agree that.
In August?
In August also.
In September?
But also, I was incarcerated at the end of August.
Okay. Incarcerated for what?
For this charge. I was arrested on the warrants for this charge.
Were you charged with the theft in Marion County on September 13th?
I was charged with that, and I am waiting for court.
So that occurred before you were arrested on this case?
Yeah, I mean, the charge
okay.
was the same, yes.
And the address that you just reported here, when did you report that address to probation?
I called, and it was August, like I said, either 2nd or 3rd, and left messages on both Sandra Kelly and Drew Balzer's lines with my new address.
Did you call Warren County Probation and give them the same address?
Warren County Probation, see the thing with that, and I've done talk to Lexi Fielder, which is my probation officer. We actually spoke earlier today, and all of this, when I was released from the STAR program, everything was supposed to be ran together. The entire time that I've been reporting to Highland County Probation, it's been under the assumption that everything was together. My probation through Highland County and Warren County, because they lifted the warrant for me to be allowed to go to the STAR program, so they knew where I was at. And the whole time I was in the STAR program, we all worked together. Highland County Probation, Warren County Probation, and Claremont County, because I was in the process of getting custody of two of my children.
So you agree you haven't reported to them either?
To Warren County, no ma'am. And like I said, I spoke to Lexi Fielder earlier today, and she basically said that depending on what happens here today, they're going to reinstate my probation because as far as they can see, I've been trying. I mean, I've been doing everything. I mean, I understand that I made some mistakes, and I'm not going to sit here and say that I didn't, but I've been trying my best in the past year to be a good person, be a good member of society. I'm an active member in my church. I work. I do what I need. I try to do what I'm supposed to do, and I understand that I made a mistake, and I didn't report in July or August. And, you know, the only thing that I can say about that also is that I had spoken with Sandra Kelly in May and Drew prior to that, and they were trying to figure out how to get my probation transferred to Marion.
But you agree it was not transferred?
No, it was not me.
Okay. And then you have a charge pending for criminal damaging and child endangering right now. When was that charge?
There's no child endangering. It's criminal damaging. There's no child endangerment charge whatsoever. I have a misdemeanor for criminal.
In Delaware County?
Yes, ma'am. It's for breaking a mailbox. There's no child endangerment whatsoever. It's for breaking the mailbox at the apartment that I live in. Is what the charge is for. There's no other charges.
I have no further questions.
May I say something?
No. Redirect?
I redirect, Your Honor.
I have a couple of questions. Picture, this Pearl Street address, you signed you have a rental agreement for that, and that's your address?
Yes, sir.
That's been your address since June the 24th of this year?
Yes, sir. July.
Okay. July, all right.
I think in August 1st.
That's where you get your mail?
Yes, sir.
Okay.
The 3068 Marion Waldo was my mother-in-law's address, and like I said, the only reason I can think of that letter got sent back is because of the lot number. It's lot 104.
Okay, well, you don't need to argue your case and answer my questions. The reason I'm asking is because on Financial disclosure form that you signed and filed with the court, you listed your address as the 3068 Marion, whatever that road is, lot something, not the 239 Pearl Street. Why did you tell the court that your mailing address was there when you have, you just told me that your mailing address is on Pearl Street in Marion?
Well, that, I can get my mail at my mother-in-law's. That's where everything goes. Like I said, we just recently moved into.
You said you moved there July the 1st. That's not recent. July the 1st, 3 months ago. July, August, September. Yeah, October, 3 months ago.
We moved in. I signed the lease July 25th, and we moved in August 1st.
Well, I'm looking at your Exhibit C. It's June 24th, 2021, signed by you and this for July. First month's report was going to be prorated July. Sarah Robinson. That's your girlfriend?
Yes, sir.
Okay. All right. Now, does either council have any questions about what I asked?
No.
No, Your Honor.
All right. Any further witnesses, Mr. Armstrong?
Listen.
All right. Reader, you have any rebuttal on this, Collins?
Only a couple questions for Ms. Kelly.
Go ahead.
Ms. Kelly, do you recall at the end of June the defendant making a phone call to the probation office?
Yes, I just looked on the records, and he left a voicemail on June the 24th for Officer Balzer. Officer Balzer gave me that name and number. I tried to call him back, and the phone was not working.
And after that, did either you or Mr. Balzer hear from him again?
No, we did not.
No further questions.
Ross?
No, Your Honor.
All right. Argument?
Your Honor, Mr. Fisher has a lot of excuses here, but the bottom line is, even if he didn't have to report while he was trying to get his $1,000 sign-on bonus, he only held that job for about half a month, then he quit, then he lost the job due to COVID. So after that, there's no excuse for him not reporting. It is his responsibility to ensure that he is reporting to the probation officer. It is his responsibility to ensure that he is complying with the probation office of both counties. It is his responsibility to ensure that they have the correct address and his correct phone number. Why he's calling in June and July, or whenever, and leaving messages for Drew is beyond me when he admits that he knew that Miss Kelly was his probation officer. She tried to reach him back. The phone number that he called from and left her no longer was working, and he made no effort again after that to get in touch with her. Since this has happened, he's been charged with additional charges. He has a warrant out for his arrest from Warren County for not complying with probation there. It's just a lot of the same. He was given judicial release on this case, a serious case, and he was given judicial release. He had a warrant for his arrest from Warren County when he was released on judicial release in order to the STAR program. So based on all of this, I would ask the court to find that he has violated the terms and conditions of his probation.
Mr. Armstrong, I did not give the opportunity to ask permission for your sentence. You were supposed to be
we can't hear you.
You guys.
I didn't ask Mr. Armstrong about his sentence. You wish to admit those?
Yes.
Was that an objection?
No, I haven't seen any of them, but I don't know.
There it is. All right. Mr. Armstrong?
Your Honor, if the court finds that he violated his probation, we're asking that you extend that. And speaking with him, one point would be, I did the math with him. It looks like there's not a lot of time to build up on whatever you do, but it does appear that these documents are legitimate. I think they are, that he does have employment, he does have a place to live. He's admitted that he didn't report in person since May 5, but the initial testimony was that there had been no contact since then, which we now know to not be true. Ms. Kelly said she found something in June and says there's nothing else, but be that as it may, the initial testimony was that there was no contact, and that wasn't accurate. You have a document that appears that he had an assessment of some type back in January of this year. Ms. Kelly wasn't able to say she knew that she had not specifically referred to any place, but he did go to this place, apparently on what we call it, an assessment. So We would just ask the court, if you find that he violated it, to continue his probation.
All right, Bo?
Your Honor, Mr. Commissioner may have a comment, I'm not sure.
I actually do, Your Honor.
No, I mean, wait, this is closing argument, Mr. Trust's attorney.
That's Your Honor, the only thing I was going to say was he may have a comment himself before you.
Well, yeah, unless I make a decision. All right, yes, Miles.
Your Honor, I don't remember what the exact testimony of Ms. Kelly was, whether she said no contact or haven't reported. I think we're kind of splitting hairs here. The probation violation, as outlined in the notification, is that he did not report after May the 5th, and I think there's no question that that's accurate. He did not report after May the 5th. He's admitted that. And while there may have been an excuse for part of June, there is absolutely no excuse for the latter half of June, all of July, and all of August. He didn't turn himself in and say, gosh, I messed up here, I need to get back on track. We had to issue a warrant for his arrest, and they had to hunt him down and arrest him that way. These are not the actions of someone who's made a mistake. These are the actions of someone who's avoiding their responsibility. Thank you.
All right. Well, the court finds that the defendant has violated the conditions as alleged. And Mr. Bolster is not a witness, all that was hearsay, and he could have been subpoenaed to robbery. And I sincerely doubt that he would have, because if they did messages from the defendant, he would have given a retaliation testimony, and she didn't have to call back. And the defendant, so the court finds the defendant violated Rule 2 and Rule 3, Rule 18, and Rule 20. The letter that was submitted from the treatment facility says that his last sentence, whatever, his last appointment was April the 1st, I believe, he received a subtext prescription. But it does not say he successfully completed or he had his case closed. It says his last appointment was with her, the CNP, as a nurse practitioner. It also says he had an assessment, an AOP assessment in January 2021, and an evaluation. And it says there he had consistent appointments being prescribed subtext. Makes no comment that he was discharged successfully, and it doesn't say that it was terminated. But again, reading between the lines, I have some questions as to whether or not he has successfully completed it, and it's his obligation to provide proof that he's failed to do so. All right, now, the court finds those violations are established now. Anything you'd like to say, Mr. Fisher, before I decide what I'm going to do here?
Your Honor, honestly, I admit that I've done wrong, and I'm not asking to be released today, but what I'm asking is to possibly, I have roughly 140 days left on my sentence, and I don't know if it's a possibility. I've spoken, like I said, I spoke with my probation officer in Warren County, and if you guys were willing, they said they were also willing to allow me to go to the Hughes program and try to better myself even more. Like I said, while I was in the STAR program, I got 12 certifications in welding. While I was in prison, I got an associate's degree in horticulture. I don't feel like going back to prison is going to benefit me at all. I mean, I've been drug-free for almost 3 years now, you know? And that was my...
We don't know that, because I don't have any evidence of that, so...
I've never failed a drug test with probation. I've never failed a drug test with access, which I understand you don't know that, but it's just what I'm saying. And I'm just, you know, I've made mistakes, but I've also worked to try to better myself. I mean, I know that what's been said today doesn't look that way, but, you know, I'm just, I mean, that's all.
How many days you spent in STAR?
133, I successfully completed it. I also completed a technical welding program while I was there also.
All right, well, it's judged before the court that you have failed to comply with conditions of control, and I find your testimony to be fairly incredible. And it's the order of the court that your judicial release be revoked, your return to prison, certain amounts of sentence in this case will be granted an additional 155 days of credit against this sentence. That's based on 22 at the sheriff and 133 days in Charlotte. And if we retain custody of the sheriff, then you can pay back. All right, thank you. You're remanded. I believe that's the end of our hearing.
Yes, Your Honor.
All right. Case Jones. I think there's yeah.
You want to go on the record?
Yeah. There's not one else. All right, yeah, we'll work. All right, State of Ohio versus Chase Anthony Jones. 21 CR 53 State versus Chase Anthony Jones. This hearing was set at 1 o'clock. For the defendant is not present, not as counsel excused because he has not been reporting to the back of the probation department. He has failed to report his office at 18. No report for sentence, and there's a warrant for his arrest in this court. So the court will case you put her back. That's your case. Your case.
Geneva, yes.
All right. Case number 21 CR 76, State of Ohio versus Dominguez, president of the state, is Judge Prosecutor King, president of the defendant, is Attorney Daniel Witt, or usually Dominguez.
Yes, sir.
Dominguez is charged with aggravated possession of methamphetamine in February felony. This is a first pre-trial, October 20, violation of 18. See that discovery and court papers have been provided. Thank you, by Janice Witt.
Not yet, Your Honor.
All right. Well, under the practice discovery, you might want a pre-trial and anticipating pre-trial motion.
Just perhaps a motion to suppress.
Okay, that'd be what on a pre-trial as well. And that's the plea offer receipt.
Yes.
Fine, well.
Yes, she is.
Okay. Any other matters then to discuss this time?
Here.
All right, be back here 2 weeks for pre-trial. Thank you. That's your only case, is it?
Yes.
All right, John Hartman.
Yes, sir, Your Honor.
Case number 21-CR-105, State of Ohio versus John W. Hartman. President of the state, Attorney King. As on behalf of the defendants, Attorney Nathan Wagner, and John Doe Hartman.
Yes, sir.
Hartman has entered plea guilty to theft by deception, a 4-3 felony. Court ordered a pre-sentence report and review that using the emergency matter and review the summary. Alright. Anything to say?
Only was contained in the plea agreement, Your Honor, the total amount of restitution is $21,900 to Jeremy Puckett and Daphne Kennedy. The defendant has agreed to pay $750 per month. It's my understanding that he has already paid $1,750. Thank you.
Alright, Mr. Wagner.
Your Honor, we would agree, Mr. King's rendition. We would ask, the court placed John on community control in this matter. Another day of the plea, he went and paid $1,000. I think yesterday he went and paid $750. I do know he's doing everything he can to stay compliant. He's working, selling the vehicles that he's got, trying to get this money paid. So again, obviously we want to see the victims in this case get paid whole. We would ask the court to take John on community control. I think we'll get this done quicker than everybody anticipates.
All right, Mr. Hartman, anything you'd like to say?
Yes, sir. Talking to CW. I've been paying these folks. I've been paying Mr. Wagner, working hard. Just like Mother Nature and God, that's good. I'm going to do it all I got to pay it all. I appreciate it. Thank you, Your Honor.
All right. Well, it's your report that you be sentenced to a period of 4 years of community control under supervision probation department. I made it 4 years because of the size of the amount of restitution. It's free, but it gets paid off earlier. The court has a general policy of after 1/2 of the term, if everything is done, this is part of all the financial obligations met, then I typically will somebody from that early, but it's easier just with a long record than 5 or 4. Now, it's your report that you pay all jurisdictions, conduct yourself in all minor matter, all time, report to the probation department. When as directed, and be truthful in all statements you make to them, as well as any answer you give to questions asked about your conditions. Repeat and inform of your residence place at all times, and understand right without prior permission. Leave the state of Ohio at any time without prior permission. Must be not entered upon grounds of a correctional facility, or may attempt to contact anyone or contact anyone in any of those facilities without prior permission. You're not permitted to purchase, possess, own, use, or have under your control any firearm, ammunition, dangerous ordnance, or weapons of any type. You're not permitted to purchase, possess, use, have under your control any controlled substance, drug abuse, CBD, oil, crayon, any burning, or any log of those substances that might be have effects similar to those substances. You're not permitted to have any instrument, device, or thing that may be used to administer drugs or any of those other items or prepare the administration or use. Unless you have a lawful prescription for those as well as the substances. And if you do, you have to provide a copy of that 24 hours received to your probation department. You must submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any alcoholic beverages or be present when being consumed or sold, even if it's otherwise lawful. Not to associate with anyone who is a co-defendant or has a criminal record, member of a gang or a criminal group, or any person who has in the past or could in the future influence you to commit criminal offense violates these conditions unless approved by your supervised officer and family members might fall within that definition, unless you're living with them immediately before the commission of this offense. You may not, after the date of this order, establish a cohabitation or common marriage involved have a relationship with another person without prior permission. If you must provide financial information records so that your ability to pay restitution fees or costs will be evaluated. Now, after the date of this order, if the probation department refers you for any evaluation or assessment for any type of programming, you're to submit to that. If they recommend any programming, you must include that. pay the court costs of this action within a reasonable period of time. You're self-employed contractor, is that correct?
Yes, sir.
All right. What were you doing for service then? You paid restitution, in the amount of $21,900 to Jeremy Puckett and Anthony Kennedy.
That's correct, Your Honor.
Through the Victim Witness Office to make the payments to them and paying service fees they charge for that service. The court will note that you've already paid $1,750 for that obligation. It's ordered that you make monthly payments of $750 a month, beginning November 1st, and every month after that until it's paid. Now, by being put under community control rather than be sent to prison, you're deemed to be consented to a search without a warrant of your person, your residence, vehicles, or any other property places under your control, or where you're found at any time by any officer of the probation department. Won't be any fine imposed. You're also ordered to pay the court costs. If you fail to make payment arrangements to pay the court costs, clerk can collect that through various means, including letters on bank accounts, rolling earnings, and other assets you may have. If that doesn't collect it, then the court will review your service. You give you credit for each hour you work, in an hour, no asset, but for each hour you work, reduce your general final amount until paid in full. Now, in the event that you fail to comply with these conditions, the probation department will file a written notice of that with the court. You'll be entitled to have a hearing and get notice of that. And if the outcome of the hearing, and you also entitled to have an attorney at that hearing. And if the outcome of that hearing is that you have failed to comply, then at that time the court could revoke your community control and send you to prison for between 6 and 18 months and fine you $5,000. If that occurs, once you complete the prison term, it is possible that the parole authority may, at their option, place you under post-release control supervision for a period of up to 2 years, meaning you'll be supervised on the terms they set, and during that period of time, they determine you have failed to comply. They can return you to prison or make you serve an additional period of up to 9 months for one violation, up to a maximum of half of your prison term, all violations. But if you committed a felony, then in addition, whenever sentence the judge in a new case imposed upon you, that judge could also sentence you in this case to an additional period of 1 year, whatever time left on that period is supposed to be control whichever greater, that occurred, that be served consecutively the sentences in your case. All right, so that completes the your report for probation department. They close at 4, so you're gonna have to go back tomorrow.
I'll be there at 8 o'clock in the morning.
Yeah, appointment, all right.
I'll be there.
All right, so you can report there tomorrow. Anything further, council?
No, Your Honor. No, Your Honor.
All right, thank you. All right, Brian Mock. Case number 210131. State of Ohio versus Brian A. Anthony Mock. President of the state is Assistant Prosecuting Attorney King. President of the defendant, Attorney Jacob Wagner. And are you Brian Anthony Mock?
Yes, Your Honor.
Pardon me?
Yes, Your Honor.
Okay. Mock charged with having weapons under disability, received stolen property, and forfeiture of medication. I believe this is a first pre-trial, actually final pre-trial, trial set for October 25th. Now, where do we stand on this case, counsel?
If I may, Your Honor?
Yes.
Your Honor, I did file my discovery this morning for the state, and I got so consumed with the actual details of the case, I overlooked one issue in this. And the reason the law enforcement officers were there to see Mr. Mock, there was actually a court order of Judge Greer's court having him probated to Claremont Mercy for mental health issues. I think I would be committing malpractice if I don't at least have a mental health evaluation done either through Twin Valley or another mental health professional. I take blame for that, Your Honor. I missed the whole point why the cops were there. I'm looking at other issues. So I will file that motion this morning or tomorrow morning. My secretary's mother just passed away today, so she left the office. So I'll need that filed in the morning.
Well, actually, I can go ahead and order that since you raised it here on the record. The statute provides it would be great. So I have any investigations there with your secretary, so we'll go ahead and order that. So that will need Mr. Mock. We're going to continue your trial date. So that gives them about 30 days to do this, and I think you understand why he's doing it.
Yes, Your Honor.
Record. And so it's important. I need to know that information as well. And so the court ordered evaluation will be done by the Emergency Evaluation Center on Hamilton, Ohio. They contacted you, they made a appointment for me to go up there to their offices, be evaluated. They'll likely report that. I'll order the vote as to the competency as well as the time of the offense, alleged offense. All right, so we'll set a hearing on that for today is October 6th, so I think November. November the 18th at 1 o'clock.
Yes, sir.
So, get your time notice from the bail therapist block and we'll go from there. So, you'll be there November the 18th at 1 o'clock. You don't have to show up for your trial date. Okay? All right. Any further counsel?
No, sir.
All right, thank you.
Thank you, Your Honor. Mr. Block will sign that piece of paper there, and I got Grandma's phone
We
number.
have 3 in the sentencing and 3 signed, but Ms. Hatner didn't come over to sign.
Sounds right.
She's still
Yeah,
waiting.
just a second.
There.
Just put an arrow there on the instrument. I tell you what, why don't you take it to Mr. Boyer or Mr. Reynolds so they can put them on the file, or if they're not there, put them on the counter.
Okay.
But otherwise, it won't get mixed up here. All right, Jeremy Bender.
He should be probably on the inactive docket.
Oh, yeah, he was full, okay. Bobby Clifford.
The same. He failed to appear at the last pretrial.
Okay, well, I recall the other case, he did show.
Okay, yeah.
I indicated that you were refused because there was already a warrant for him at a warrant, child reporting.
Okay, they didn't know anything else. Okay.
Yeah, well, he did not show.
Okay, I didn't hear you. Thank you.
All right, no problem.
Yeah. I just shaded that place. All right.
Both of those that were on inactive docket.
Yeah, they're inactive, they should have been pulled off. Should have been, removed.
I knew you'd get.
Case was inactive, I don't know why the court doesn't go in there and just remove those. They don't.
Well, you got done on time now.
Here's what happens. You don't show up for the appointment, the judge has no other recourse than to put you into custody, and you're appointed out of jail. So when I say, hey, here's this time, this date, that doesn't mean I'll think about showing up at that time. Yeah, you're verbal phone. That's fine, that part is great, but that's going the right track. I can call Grandma. Emergency time, okay? You gotta let me know. Now, if today someone's sick or someone needs a ride to work, that's not an emergency. Emergency is someone's in the hospital, the house just caught on fire. But it's not gonna happen. I get it. COVID comes up all the time. I get it. Like I said, I'm not being mean, to be honest, that's my job. If he doesn't show up, I know you're wrong. The judge will say, you know what, I'll just take it into custody, we'll do the evaluation. No, all right? Keep reporting, on the FRS, say contact. All right, guys, thank you. Good job.
Yeah, I'm understanding her, right, up here. So, now, I might not be able to do that.
Mhm.